No orders at cause.
May I be pardoned to make a mention?
Additionally, give that slip. He'll look into it.
I may be permitted to take your lordship's leave in mention. I am here. Permitted to take your lordship's leave. One WA disposed of matter by Honorable CJ then and Honorable Justice C.R. Das. My lord, may I pray the LRs have approved this Honorable Court for substitution setting aside abatement. Notice has to be formally issued. My prayer before your lord
WA has been disposed of.
disposed of because it has abated. Now LRs have come forward before this Honorable Court because the original, I am the original counsel. My jurisdiction is to the limited extent of intimating to the court that so and so has expired. Now the LRs has come for substitution, setting aside abatement and condemnation of delay. May I pray day after tomorrow any break bench it has to be listed. Honorable Justice C.R. Das was a party to the Honorable Chief Justice then, my lord, Justice Muraldhar. And may I pray, my lord? I may be excused that 10 memos I have
You
given.
please do it. When had you gave 10 memos?
Today?
No. When had you earlier given?
Staged over a period of 2 to 3 months. I have been giving memo and personally myself went, my associate went, my lord, no result.
You give it right. This time you give it.
Yes, and obliged.
I mean, pardon my lord, as the honorable single judgment has been preferred, state has preferred a writ appeal before this honorable court. Since last 2 years, the case has not come. The petitioner,
You are
I am the respondent, my lord.
respondent. Have you filed any application for vacating the order?
No stay order has been passed, only notice has been issued, my lord. Then thereafter, the case has not been listed, my lord.
So it is someone else's appeal, Mr.
My lord?
It is not your appeal.
No, state appeal, but I am deprived of getting the benefits, my lord, time-bound advancement scale of pay.
That is different.
because-
You can file a contempt petition.
Contempt has been already filed, my lord.
Then
Contempt has not come.
why do you want hearing of the appeal which has been filed by someone else?
Then writ appeal may be disposed of, my lord. I may get my benefit.
When did you file your appeal?
Appeal state has filed the appeal.
When was the appeal filed? Sorry.
2022. 2022. The judgment of
There are so many writ appeals
2021,
pending.
17/10/2021. The judgment had been delivered by honorable single judge.
We can entertain your mentioning only if you have consent of the other side.
Consent is state, man.
State gives, because it is their appeal.
Yes, man.
They may give consent, they may not.
Let it be listed. Please furnish the number.
Give your slip.
Memo there, number.
Another minor contempt matter, my lord. Another memo contempt matter.
One mentioning a day.
It's a writ appeal matter, my lord. Yeah, sorry.
I will be pardoned, my lord. I don't know the process.
No, there is nothing wrong with the process.
It's a
What is the contempt matter? Just a minute. What is this contempt matter about?
Contempt is matter, the single bench, the honorable, this honorable bench has passed the order for some release of some outstanding dues by the Municipal Corporation Cuttack. So the order dated, order has not been implemented well. The order dated 13/10/2023.
Mr. Samandra is sitting, give your slip to him.
It is municipal corporation.
Oh, give that slip to me. Give
So
your
Mr.
slip.
Pranay Mahanti may be appearing.
Devasis Naik.
Devashish Naik. Mr. Devashish Naik.
Just tell him that this mentioning you have met, and we may list the matter anytime.
I will inform him, my lord.
Just inform him. Give this slip to him. Not to us. Give this slip to Mr. Naik.
Devashish Naik. Devashish Naik.
Memo.
Well, I'm a foreign to mention.
There is no procedure, Mr. You have only grievance that some order passed by this court is not being complied with.
My lord.
You tell the lawyer who appears on behalf of the Cuttack Development Authority,
Municipal Corporation.
Cuttack Municipal Corporation, that a mentioning has been made and the matter may be taken up after some time. Just inform him. He may tell his client, he may ask his client to comply with the order. There is not any, there is no any procedure of the kind which I am suggesting you. Just inform him. Make a mention after 2 weeks. If in the meanwhile the order is not complied with, your case will be listed. All right.
Yes, ma'am.
Oh,
Oh, great, Commissioner.
I pardon, my lord.
Please.
It's a retail matter, my lord. But this is matter relating to the approval and the release of the grantee land, my lord. That's 2022 matter. That is the
Wait for some time.
that is 2013 grantee land is not getting. Others have already sent for approval and release.
Sir,
of grantee.
there are so many matters, old matters are pending. We are struggling with those matters.
Let it be listed.
Listed for the sake of listing. Make a mention after some time.
Well, this is a retapil, my lord, of the year 2021, my lord. There is a civil, actually, I have purchased the land, my lord, but could not be recorded my name. When I go to recording before the competent authority, my lord, he told, no, it is not permissible, my lord. That's why I have challenged before your lordship, my lord. Single bench rejected that we go to suit. Suit is not maintainable in this case. Only writ application is maintainable. That's why I have.
Make a mention after some time. After some time. After 2 weeks or after vacation, make a mention. In the meanwhile, I'll try to find out cases of which year are pending.
21, my lord.
No, I'll try to find out from the registry cases of which year are pending, and then get them listed properly.
Lordship, on
Yeah.
WPC number 26805 of 2023. I pray this matter will be listed along with item number 55 that is listed today, Your Lordship. This matter has been somehow left out, Your Lordship. So therefore, I pray along with item 55, this matter will be taken up.
Yes.
Cess admission item number 2.
Please, Your Lordship.
Under this writ application, the petitioner phrase that the others have encroached the public land wherein the ingress and egress of the petitioner to the road is not being
So you
taken
can
care
apply
of.
that.
My lord, recently,
case.
my lord has passed the judgment.
Yeah.
Which has
Follow
been
that.
taken care of all these aspects. So far, the encroachment is concerned. I have gone through this. On that light, it may be taken care of. So far, the reprehension.
All right.
Should I forward it, my lord, that
Which
judgment?
Panda? That's Sankar.
This is Trinath Panda,
Panda.
3385 of 2020.
Yes.
Item number 3.
Because item 3 is a contempt application, my lord. Here, if your lordship kindly sees your lordship's last order, that is order dated 3/4/24. Your lordships are directed by way of last indulgence, 3 weeks further time is granted to the contender to ensure that this court's order dated 1/12/22 is complied with in letter and spirit. What has happened in this case, my lords? My lords, the petitioner is a cooperative bank, my lords. It was allotted lands now on which a judicial academy is situated. Now there was a proposal for exchange of land, we agreed to it. And my lords, alternate land was to be allotted to us by the Tahsildar. Land was taken over by the Judicial Academy, my lords, and alternate lands were also, my lords, allotted to us. But no proceedings took place before the Tahsildar and it remains as such. So we cannot build up our head office, my lords, in the meantime. That is why, my lords, for such a long time, this matter has been pending. But no action is being taken by the government to allot.
Lordships are pleased to be allowed because in fact there was exchange of land. Land was also identified by both parties But their allegation is that still not possession is not being handed over, or if any formalities is not complying with. Lordship said directed on 3rd of March, April, my lord. I had written him a letter, he has not replied to it. Lordship may take it out tomorrow, my lord. So I will ask him to be present before Lordship to explain why he has not complied with. Only Kotak, my lord.
Is an admitted position that this court's order dated 1/12/2022 passed in WPC number
WPC number 25496 of 22.
has not been complied with. Despite this court's observation made in the present proceeding on 3/4/2024. Most of prima facie, it appears to us that the disobedience of this court's order is deliberate, is willful and deliberate, and calls for initiation of contempt proceeding against the contender. Stop. Let the contender be present in court on Friday at 10:30 a.m. for this court to consider initiation of contempt proceeding against him. This matter on Friday. Yes.
Obliged.
Item
Got
of
any intimation?
Yep.
Got any intimation in this regard?
Contempt.
Now?
No. It's next item. Lord. Next item, intimation is come.
item 4.
No, it's next item.
So in the state of Odisha, thousands of contempt have been committed,
Right.
and in none of the cases you have been punished.
So because of Lordship's indulgence only, we are trying to, otherwise, I admit not clear cut.
All right.
Here not, we have complied the order. Lordship may grant me sometime, it has been done, only payment has to be made. So 1 week time, in the meantime, we'll pay the amount. I can give a copy to my friend, we have done everything, Lord.
Yes, madam. Yes. We are making all efforts so that the orders of the court are executed.
Yes.
As requested on behalf of the contender, list this matter on 1 week so as to report full compliance of this court's order.
Item number 5.
May it please your lordship. Lord, here petitioner is a bottling plant, my lord. Lord, here the opposite party number 5, Radico Khaitan Limited, Lord, tied up with
Which opposite party number 5?
Radico Khaitan Limited. Lord, he tied up with the petitioner company to manufacture of his brand. Lord, we have manufactured and Lord, stocks were dispatched, but some stocks were not dispatched and it becomes unfit for human consumption. Now the collector and commissioner has passed an order directing that to pay excise duty on this unfit for human consumption. I have challenged also the rule under Rule 99(7)(b). The rule says that if it is unfit for human consumption, then the licensee is liable to pay duty of one-time fine as penalty. That I am challenging is ultra vires of the act.
This is a new trend.
Yes.
That if you are aggrieved by an order passed under some statutory provision, you challenge the statutory provision itself.
But it is, Lordships knows that it is once it is unfit for human consumption, it is to be destroyed.
Yeah.
The order has been passed. Commission has passed an order for destruction of the stocks. But in that order, he has said that a destruction will be made subject to deposit of excise
So
duty.
he is correct.
Not
According to you, law is incorrect.
But excise duty cannot be leviable on the unfit for human consumption.
Where is that?
But it is contrary to the 51 of the list 2. Entry 51, list 2 says duty is leviable on fit for human consumption.
Where is that?
May I read, my lord? entry 51 leads to 7th schedule. Duties of excise on the following goods manufactured or produced in the state and countervailing duties at the same or lower rates on similar goods manufactured or produced elsewhere in India, alcoholic liquors for human consumption.
Yes.
A.
So you had produced alcoholic liquors for human consumption.
Yes, Lord.
Later, they were not worth human consumption.
Yes, Lord.
Later.
Yes.
So at the time of production,
Yes.
it was this thing. It was for human consumption.
Yes, Lord.
Then,
If it is not during manufacture, it is human consumption.
so
On
during the
removal,
manufacture-
Lord, on removal, I'll pay the duty. It has not been removed from my production unit.
No, the word is manufactured or produced.
Yes, Lord. Lord, that they have not collected at that time.
For human consumption. Yes.
Lord,
For human consumption.
Lord, this provision of law, 2017, earlier it was there and it was challenged. And this Honorable Court has struck down that rule, Lord.
Which rule?
Lord, earlier, this rule, 99(7)(b), it was earlier 39(b), 7(b) was there. And that was challenged by, before this Honorable Court.
So where is that judgment?
Yes.
And
Same parametry,
what
same
you are-
parametry of provision.
what
There,
you are
Lord,
saying-
5 times was there. Here, 1 time is there. Duty. Earlier,
The logic which you are giving appears to be irrational.
the Lordship kindly glance para 4.2. Page Lord 932. And counsel for the petitioner, referring to the above provisions, submit that new rule 39A(7)(b) was introduced in exercise of power, section 90 of Beer Excise Act, but nowhere in the act, neither the word penalty is there, nor it has been prescribed to impose penalty by framing rules. Therefore, the rule-making authority has travelled beyond the scope and has imposed such condition, which is ultra-vires of the act. Then, paragraph 5.1. Though this writ matter was filed in the year 1995, and so matter was admitted and order was passed for fixing the matter to opposite party. Final hearing. However, no further reply has been filed by the opposite parties. A counter affidavit was filed on behalf of the opposite parties, wherein an endeavor has been made to show that the authority has rightly imposed penalty. It is stated that the said rule has been introduced to prevent storage and supply of unhealthy liquor, which is unfit for human consumption. And therefore, in the said rule, it is stipulated that if any stock of IMFL beer stored under Rule 33(6) becomes unfit for human consumption owing to long storage or for other factors, the licensee shall be squarely responsible and shall be liable to pay penalty. Therefore, it is submitted that same cannot be said to be unreasonable and illegal. Lord 6. Be that as it may, after going through the said counter, we are not in a position to find that opposite parties have sufficient reason and power to impose such penalty, more particularly when Section 90 of the Act, which confers power to board make rule, does not empower the make rule for imposition of penalty. Clause B under Rule 39(7)(b) board schedule for imposition of penalty.
You are challenging what?
Not,
You are challenging what?
not penalty. 99(7)(b). Rule-
99(7)(b).
Your
Let us
Lordship,
see.
kind of.
So that logic is not there, that it is violative, unconstitutional because of this entry 51.
But
The
that-
reason is something else.
Yes, but I have the Lordship kind of glance 99, sub rule 7, and clause B.
Odisha Excise Rule,
No, what is the excise rule?
Excise
No,
rule.
2017. Milord.
2017,
Yes,
Rule 99,
Milord. 99, sub rule 7, Milord.
is something else.
7 and B, Milord. Clause B.
Odisha Excise Rules. Acha, D, sorry, B,
Milord,
B,
Milord.
B.
Clause B, my lord.
Clause B, just a minute, just a minute.
Yes. If any stock stored becomes deteriorated in quality due to leakage, sedimentation, damage to container, or becomes unfit for human consumption owing to long storage or for other factors, the licensee shall be squarely responsible and shall be liable to pay fine equal to the duty payable to the state government on the stock so spoiled, along with 10% of excess over the amount so payable.
All right, the rules are framed in exercise of which power?
No, 90, rule 90. No, that is, in the first it is there. Section 90 read with section 94.
Oh, that's fine. That is not penalty. to regulate movement, possession and sale.
Yes, my lord.
So that is not covered by 94.
No, my lord. And
Yes, file
Right.
your, there
Yes.
appears to be prima facie case.
We'll file our.
Uh, the present writ petition. The petitioner has challenged an order dated 5/12/2023 passed by opposite party number 2, whereby he has confirmed an order of the order issued by opposite party number 3 dated 24/3/2023 pursuant to demand notice issued to deposit issued to opposite party number 5 but opposite party number 5 is not
they,
approaching.
yes, the demand notice is issued to OP number 5, but ultimately collector given finding that you pay that amount and recover from him.
Because he is the license.
Because I'm
Who is the
licensee, he said. Here, blood, the OP number 5 tied with me and he manufactured his brand and he is to sell out his product. But collector illegally has fixed the liability on me.
That is an internal arrangement between petitioner and OP number 5.
But that was approved by the commission.
License is always accountable to the department.
Excise duty amounting to rupees 33,544, including 10% fine towards destruction of stocks of 1469 cases of IMFL produced by opposite party number 5, which were declared unfit for human consumption as per Rule 99(7) of the Odisha Excise Rules 2017. Stop. Learned counsel for the petitioner has argued that he is the licensee and the respondent number 5 produces
His brand. Produces his brand, my lord.
His
brand of
brand.
IMFL. IMFL, India made foreign liquor.
produces IMFL of its brand under the license granted in favor of the petitioner. And accordingly, the petitioner has been asked to pay the excise duty and fine of 10%. Stop. Next, he has argued that the said orders have apparently been passed exercising power under Rule 99(7)(b) of the Odisha Excise Rules 2017. He contains, referring to rule, he contains that he said Rule 99(7)(b) of the excise rules is ultra virus the provisions of Odisha Excise Act 2008. First off, he contends that sections section 90 and 94 of the Odisha Excise Act confers power upon the state government to frame rules with respect to the items mentioned therein. First off, he submits that the said rule does not provide for imposition, that the act that in exercise of power under section 90 and 94 of the Act, no rule could have been framed for imposition of penalty, as the provisions under section 90 and 94 of the Act do not confer any such power on the state to frame rules. In this regard, first off, he has pointed out that he has argued that similar provision was there in the nature of section, Rule 39, Rule 39A, bracketed 7, bracketed B of the board excise rules.
Yes, sir. Earlier it was boards.
Of the board excise rules 1965, which was struck down by a division bench of this court in its judgment in case of so and so, reported in 2019 volume 1 OLR 928. Stop. Section rule 99 bracketed 7 bracketed B of Excise Rules 2017 reads as under. So stop. The rule 39 hyphen capital A.
Below.
Capital A
Bracket 7,
bracketed 7 bracketed B of the board excise rules 1965 as it then existed, read as under. Stop. On comparison of the two provisions, we find substance in the submission made on, we prima facie find substance in submission made on behalf of the petitioner that they are parameteria with each other. So stop. We are also prima facie satisfied with the submission advanced on behalf of the petitioner that a coordinate bench of this court in case of so and so, Sovelis.
Yes, please.
Sovelis bracketed supra had struck down rule 37 39 bracketed A bracketed 7 bracketed B of 2000 of board excise rules 1965 on the reasoning that Section 90 of the Act did not confer such power on the board to make rules for imposition of penalty. First off. Next. Issue notice.
Yes, I will accept notice for all the opposite party.
Accept notice on behalf of the opposite party.
6 weeks time.
6 weeks time is allowed. But if
I'll take notice, OP number 5, registered post or speed post.
issue notice, accept opposite party number 5. Issue notice to, he is your person.
No, my lord, he is no, because my lord, this unit is closed 2019. No more functioning.
Issue notice. For registered post and speed post. But we will stay only this part, 10%.
That is there.
Not
That
beyond
is
that.
That is.
So. In the meanwhile.
The duty
Yeah,
money
this
demand
is-
is 32,48,675
In the
and
meanwhile,
penalty is only 3 lakhs.
considering the above noted facts. In noted facts, we direct that in the meanwhile, the opposite parties shall not insist on recovery of 10% of fine imposed by opposite party number 3.
In the
Opposite party-
demand notice annexure 5.
Yeah, demand notice bracketed and extra 5.
I have also interim prayer to destruction of those stocks.
Hmm?
Destruction of those stocks which are lying in my
Bracketed.
unit.
Bracketed.
Item number 6.
Grant of, similar matter, madam. Grant of, similar. Only directed that he file, and then next year, my lord.
Item number 7.
May I please, Your Lordship? Your Lordship, challenge made to constitution and validity of section 16(2)(c). So yesterday, Your Lordship has passed the similar order. Item 12 supplementary list fresh admission.
Yes, but similar to the yesterday matter.
Correct it and give it. Necessary corrections according to your.
Demand, quantum of demand.
The necessary corrections.
Your Lordship. Order has not yet. I am for the OP3. I am for the OP3 in this case.
Do it in the middle. We are not passing. Yes.
Item number 8.
Today, my lord, I have filed a memo with the registry granting no objection certificate to the petitioner.
You have filed.
My lord, I have filed.
Writ petition you have filed.
No.
Writ
Yes, I am
petition was
counsel.
filed through you.
I am the
The
counsel.
writ petition was drafted by you.
My lord,
You should have taken care of
I'm sorry.
all the circumstances.
I'm sorry.
So you have taken this. The lawyer cannot say that you are also responsible. You knew, you could have advised him properly.
I may be excused me.
Therefore, you will have to also to see the nature of order we issue. Give us, you're all right. We are accepting.
My lord, I am the petitioner. I am the petitioner in the case.
Right.
I am present here today itself because last evening my advocate told that he wants to withdraw the writ. I told him, since it is my writ, I will also remain present in the court
Alright.
and pray that my writ either, since he has already left the
No,
case.
we will not allow.
Sir,
We will not allow. We will not do that.
no,
We
sir,
will not
kind-
allow you to
kind-
withdraw the writ petition because of your conduct.
My conduct, sir.
Yes. You will see that in our order. And what is your return, annual return? How much return do you file? What is your annual income?
My income is more than 10 lakhs
More than 10 lakhs?
per annum.
Exact amount?
Exact amount, sir, I will find out from my income tax return and tell you. It is more than 10 lakhs.
Because if we impose cost, we in fact intend to impose cost of 5 lakhs. Will it be more for you?
Sir, that is why, sir, I am remaining present and I am making a prayer.
How much?
Because the case, since my advocate has already left the case, kindly allow me 15 days time to give another advocate and pursue the case.
No, sorry.
Because this is a question of constitution and I have given you all those documents where Mr. Postma has filed one false affidavit. By giving this false affidavit, he has gone to the Rajya Sabha, he has become the members and this affidavit here, sir.
We are dealing with your case.
Sir.
Yes. Listen to the order. Respondent number, opposite party number 3. You can take a seat.
Sir.
Do you want to argue something more than what has been argued?
Sir, I'll just tell you that because all these documents I have given to you.
All the documents, Mr. Those documents, when did you get those documents?
These documents came to my notice in 2021.
2021.
July 2021, sir, specifically.
Have you mentioned in your petition?
Yes, sir, I have already mentioned.
That you got it in 2021?
21.
So what did you do thereafter?
Then, sir, all those procedures I had to follow because I had to write to different authorities to get it confirmed whether this affidavit has been filed by him or not. Then I went to the Election Commission of India. Election Commission of India on 15th of February 2024, they registered my case, gave me my number. And after that, 15th of February, then Mr. Ashwin Basu filed nomination for the second time. He was declared elected. Then I wrote to the Election Commission and kindly said, this is the document I filed in the email. And they gave me that we apologize for the inconvenience. And after that, when the 29th of February, they didn't do anything. I gave them 15 days time. After 15 days time, I go to court.
You came before the court?
Sir.
So he's right. You insisted. You compelled the lawyer to file the writ petition.
Sir, I gave him the documents. He told me that because the case has not been taken up the Election Commission of India, there is some lapse. Court may also, we cannot waste the valuable time of the honorable court. So that is why when I filed the complaint with the Election Commission of India.
So your lawyer advised you? Your lawyer advised you to file this writ petition?
No, sir, because writ petition, I insisted because I gave all the documents to him.
And therefore.
And when the matter is pending, till that, sir, they're telling that it is we are doing something, they have not done anything. So that is why I came to the honorable court. That let them give at least it should be admitted and they should be given a reply. Why they are not giving a reply?
Opposite party number 3 is a union minister. He was elected as a Rajya Sabha member. A member of Rajya Sabha on
No. Subsequently to work as a minister under the Union of India on 7/7/20, that is paragraph 5.
And he was elected as a Rajya Sabha member from Orissa. And when was he elected?
Sir, in 2019, sir, June 2019.
28/6/2009.
Page 4 of the writ petition.
Page 4.
Paragraph 5.
On 28/6/2019. Oh, stop. The petitioner has filed the present writ application seeking issuance of writ of mandamus to the Election Commission of India to complete an inquiry in accordance with law within a stipulated time on a complaint submitted by the petitioner with respect to filing of a false affidavit by the opposite party number 3. While submitting his nomination papers for election to Rajya Sabha.
Right.
Full stop. Next. There is averment in the present writ petition. Okay, there are amendments in the present writ petition that opposite party number, that the declarations, certain declarations made by opposite party number 3 in the nomination papers were not correct. Full stop. It is his contention. It is also pleaded that OP number 3 contested and won the election on and contested and was declared successful for Rajya Sabha on 28/6/2019 based on false affidavit submitted by him. Full stop. The petitioner, next paragraph, the petitioner is neither an elector to the said election process, nor was the petitioner had not contested the said election, nor was an elector to in the said election. So stop. When were the elections notified?
So for this time, sir,
General elections.
no, because he was elected.
Please, Mr. Parija, when were the general these elections notified?
18th of March, 2024 for Odisha. Lordship, please.
Nor was an elector in the said election process. Full stop. Next, the general elections were notified on 18/3/2024. Full stop. Next, it is the petitioner's case as pleaded in the writ petition that he had made a complaint to, where is the complaint?
That was on 15th of February, sir, 2024.
Made a complaint to
Election Commission of India.
the Election Commission of India on 15/2/2024, raising the 24 making an allegation that opposite party number 3 had made false declaration in his nomination papers. So stop. Where is that email?
The document, my lord, is
Where is that email? Email which he had sent.
my lord, he has sent this document at page 58, annexure 6. And email is at page 68, my lord, annexure 7.
Two weeks thereafter, he sent an email to the Election Commission of India to the following effect. वो quote कर दोगे page 58. Stop. It further appears from annexure 7 of the writ petition that the Election Commission responded to the petitioner's email message in following terms. On what is the date?
29, sir.
29 February 24. Your petition.
On the same day.
So, can you? Fifteen to 2024 at 1:03 p.m. Next. It further appears from annexure 7 that on the same day, the Election Commission of India responded to the petitioner's message mentioning as under. Responded to petitioner at 2:23 p.m. At 2:23 p.m. So stop. The very next day, after the general elections were announced, the petitioner filed the present writ application on 19/3/2024, seeking direction.
Similar, the general election is for Lok Sabha. This is getting Rajya Sabha. Rajya Sabha notification has not come with the Lok Sabha notification.
You shall not interject till we complete the order. Please take your seat. On 20th कर दे रहा हूँ. So 19th 20. Several averments have been made in the writ petition, which are not required to be referred to in the present order, as in the opinion of the petitioner, the conduct of respondent number 3 in making false statement amounts to an offense. Or stop. Offense under the provisions of the IPC and Representation of People's Act 1951. 1950.
51.
No, there are two acts. One is 1950, other is
Offensive
1951.
under 1951. If my
This is
lord
what-
may kindly see section 125.
You are right. You are right. You are right.
Offensive under
1951.
51.
1951. Oh, stop. The petitioner, in the writ petition has also referred to certain Supreme Court's decisions. Oh, stop. The present writ application was filed through Mr. Siddharth Prasad Das, learned advocate. Oh, stop. While making his submissions on last day, yesterday, making his submission, he vehemently argued that the Election Commission of India was sitting tight over the complaint made by the petitioner, and therefore the petitioner invoked extraordinary writ jurisdiction of this court under Article 226 of the Constitution of India, seeking direction to the Election Commission to conduct and to complete the inquiry based on his complaint forthwith. Stop. For passing appropriate orders, the matter was adjourned for today. Stop. Next, today, Mr. Siddharth Das, learned counsel, has submitted a no objection memo withdrawing himself from this case on the instructions of the petitioner. Stop. He has submitted that it was on the insistence of the petitioner that he had filed present writ application. Stop. Next, the petitioner is present in person. Stop. He submits that in view of the seriousness of the allegation made against opposite party number 3, the Election Commission ought to have inquired into the complaint made by the petitioner, ought to have completed the inquiry based on complaint made by the petitioner. First off. Next, after having carefully perused the pleadings in the writ petition, we are of the definite view that this writ application, that filing of the present writ application is total abuse of the process of the court. Stop. Further, filing of the present application appears to be politically motivated, which has been filed soon after declaration of general elections against the opposite party number 3, who is an union minister, who is a union minister. It is curious to note that the petitioner, in his communication addressed to the Election Commission through his email dated 29/2/2024, put questions as to why opposite party number 3 was declared elected to Rajya Sabha later from Odisha government, from Odisha, and given the certificate by the electoral officer when his complaint was pending. So stop. It is noted that after completion of term of election to Rajya Sabha in 2019, opposite party number 3 has again been elected to Rajya Sabha in
24 man.
in 2024. It is in that background the petitioner, in his message to in his mail to the Election Commission, has questioned. It is in that background the petitioner has questioned as to how the certificate return, as to how opposite party number 3 was returned to Rajya Sabha when his complaint was pending. Stop. Further, despite the fact that the Election Commission of India had immediately responded to the petitioner's mail, the petitioner chose to approach this court by filing the present writ application less than a month after the said communications. Within 20 days. Within 20 days. Within 20 days. 20 days, eh? Within less than a month from the said communication. So stop. Next. It is not that the court exercising writ jurisdiction under Article 226 of the Constitution of India may not entertain genuine litigations having political overtones. So stop. However, we find from the pleadings in the present writ application that the writ application, as has noted as has been noted above, that this application is politically motivated. First off, the courts exercising power of judicial review have a duty to discourage filing of frivolous and vexatious writ applications. First off, filing of such applications clog the courts with unnecessary litigations. First off, the courts, because of such litigations, find difficult to adjudicate upon genuine litigations. First off, in order to discourage such kind of frivolous and vexatious litigation, we are of the view that exemplary cause should be imposed in the present case. First off, this application is accordingly dismissed with a cost of ₹5 lakhs to be paid by the petitioner. 2, in the account of High Court Bar Association, High Court.
High Court Bar Association Advocates Welfare Fund.
Yes.
Yes. By within 3 weeks. Yes. Next. Has assisted this court. First off, we record our appreciation for the assistance extended by him to the court.
Yes.
You appear.
Assisted to my senior.
He is for election commission.
My lord, I only want one clarification. 18th March is for the state of Odisha, because
No, for parliament.
yeah, parliament also for different states, first phase, second phase, third phase. So we are, Your Lordship, may only clarify, my lord, 18th March for the state of Odisha.
18 March for the state of Odisha.
Grateful. It's great.
Election commission of the
And please be careful, Mr. Counsel. In future, you may be in serious trouble. I must tell you.
It is because of inconsistency, also. With great respect, I am sorry. Deeply obliged, my lord. Immensely grateful.
Item 9.
You are Gopal Agrawal.
Yes, for Election Commission of India.
Beg your lordship, item 9, copy not serve on the state commercial tax. As because the notice has been issued by us, I have gone through my learned friends copy. He is appearing for the center because they have challenged the notice of 28/12. In the meantime, order must have been passed, and this notice must have merged with the order. So
I have an instruction, no order has been passed yet.
let it serve a copy. I will take instruction. Let it be tomorrow.
Tomorrow.
Yes.
Serve a copy. We are not passing any
Obliged.
order.
Obliged.
Is that matter?
168A limitation.
168, they have extended by virtue of notification.
Yes. Extended at a belated stage. Your lordship has already batch of cases. Force measure issue. Batch of cases are pending here.
Not coming within the period of force measure.
Force measure, your lordship.
Force measure, they have.
On the ground of COVID, they have extended this issuance of order.
What is their stand? Why don't you resolve it?
Most probably notice must be the final order. Order must have been passed.
Order, maybe, but you should take a conscious decision now that cannot be covered.
We have filed,
Force
Other cases are pending.
other
What are
cases are there in which few of the cases we have already filed counters. Because in the present case, just
Don't you find it difficult to defend your case? Whether your officers don't understand. Why are you compelling us to decide?
This is from GST Council.
Yes, CBI, Central Board of.
They are functionaries of they are executors.
No, they are executors. They may be executors, but you are lawyer. You are lawyer for the central government.
because, my lord, we have filed counter in this state government.
GST Council.
You are for the state government.
I am for the
Who is
state.
for the union of Mr.
Pari and
He is not there.
Mr. Satpati accused for GST Council.
No, he is for the CGST
CGST.
along with this area.
Union of India, this Department of Minister of Finance, Central Board of India
All right,
Taxes.
we will take up tomorrow.
So you ask Mr. Pari to be if he is appearing for GST Council. Who
Your
is
Lordship.
appearing for the
And
GST
this matter
Council?
whether this matter has been decided by any high court.
Not
No,
yet.
all the high courts, so they are on the system of the matter. Only interim order, they are protecting wherever the demand has been raised, it has been protected.
Let it be decided then. If you don't do anything, then we will decide. That is the
In my
only
case, it's a so cause has been
that
challenged.
is the only issue involved.
Only issue involved, your lordship. In my case, only so cause notice has been challenged, and your lordship has passed the order ki no final orders had be passed without the leave of the court.
Only have to
And
check
when
whether-
those matters are
Batch cases are there, your lordship.
coming when?
Oh,
Those matters-
not yet
Is
fixed.
there any date fixed there?
No date has been fixed here.
I have the list of batch cases, but in fact, I have to check this matter only to be
No,
taken
we
up.
will get all those matters fixed.
I have
In my case, your lordship, this limitation period in the extended period expired on 30th of April. So this so cause notice. I have filed the replies. So your lordship is passing ki no
I have
final
to
orders.
just check it, your lordship.
How can we find out?
Because
7 cases तो अभी है ना? हाँ? Total कितने cases हैं?
no order has yet been.
In these cases, we have already issued notices.
Lordship.
Your lordship.
You filed your counter.
In a few, we have already filed counters.
We can decide one of the cases. No? One of the cases we can fix.
My lords.
Mr. Mahanti, why don't you inquire whether Mr. Pari is appearing for GST Council so that we can appraise him and let him be present tomorrow.
Tomorrow we will fix a date
Your lordship.
for hearing of one of the cases. Any one in which pleadings are complete.
But maybe
If that is the only legal question, that can be decided in any of the cases.
Grateful, your lordship. Your lordship, actually this so cause notice has been, so as on today, they have not yet passed any order.
let them pass, they will face the jury.
Grateful.
You file affidavit.
Yes.
Item number 10. Item number 10 may be taken up along with item number 55.
Why?
55, similar matter, 55 matter has been fixed at 2 p.m. Same matter.
55. 55 has been fixed for at 2 p.m.
2 p.m.
All right. Just remind us when the 55 is taken up.
Item 11.
Annexure 3 is pending before opposite item number 2 regarding the benchmark valuation.
Hmm?
Regarding the benchmark valuation, my
What is pending?
annexure
Copy of
3,
representation.
annexure 3, my
Difficult.
page 20.
You will not do that. Yes, what is your case?
My petition, although as per rule, my lord, for a constitutional valuation committee to private person is to must be present, my page 12, my lord, the rule I have annexed, my lord. Page 12. Rule 37, it has specifically mentioned two public person to be nominated by the chairman. Or the
Page,
district
rule?
valuation committee.
Rule 37.
Page 12, my lord, page 30, page 12, my lord, rule 37.
Which rule?
Rule, my lord, the Odisha stamp rule 1952 amendment.
So what do you want?
The proper constitution has not made, that's why we have made objection that annexure 3 that is pending.
This amendment rules is of 2001. Wherein
My lord. My lord.
chapter 6 has been introduced.
My lord.
Rule
Now-
37, rule 37
My-
provides for constitution of the
my-
committee, valuation committee.
My lord. My grievance is on the annexure 2, page 15, when the district of Gazipati, the committee was held on page.
Mr.
Doubt.
What do you want? Constitution of a committee?
No, my lord.
Then
I have read annexure 2, my lord, the committee was constituted. So, but that committee is not properly constituted. That's why we have raised the objection.
He wants to quash that benchmark valuation.
This constitution is not in accord with the rule 37. Do you mean to say that?
My lord, page 15, my lord, page 15. The proceedings of the district level valuation committee meeting held on 2/2/24 for biennial revision of benchmark valuation for the year 2024-26 for the district of Gazipati.
so what is benchmark valuation? Circle rate. Yes, circle rate. It is called circle rate or something. No, you call it benchmark, benchmark, we call it circle rate.
My
So in some of the places it is called circle rate.
rate.
All right. So you are challenging the benchmark valuation.
My
How?
not challenge.
He challenged. The constitution of the committee
Committee.
is not in accord with
Rule. My
this 37.
It's because the committee says two private persons are supposed to be there.
Yeah.
So he's saying despite all these officers, why two private persons were not there during the constitution of the committee which decided on the benchmark valuation?
That's why I raised my objection
But that-
under annexure 3.
All right. Let us see the rules.
Page 12. Page 11.
Collector is there?
My lord.
Collect-
Which member is not there?
Page 12, my lord, two public person to be nominated by the chair.
No, your lordship may see the constitution of the committee at page 15. Page 15 of his read.
Please, first rules we are examining.
Ah, yeah.
37, clause 8. Two public persons to be nominated by the chairman. Page 12. So then, what is constituted? That is at page 15.
My lord.
The two public persons are not there.
My lord.
So where is the constitution of committee?
My lord.
Where is the constitution of committee?
Page,
Committee has been constituted.
my lord.
So where is that?
Two public persons are there, it seems.
Uh,
Name actually,
Yes, madam, retired OS.
last two, my lord.
Huh.
Name actually reflected was page 23, my lord. 22.
persons. Page 50.
I have
Yes.
Last 3%.
Yes. What is wrong? And you want us to get your representation disposed of?
my
They
lord.
are there.
No, my lord. I have specifically about my retention as also in my.
Mr. Counsel,
paragraph
please
7.
come to the last two names.
My lord.
Birja Prasad Patra,
Patra and Y.S. Murthy, my lord.
huh? Y.S.
And
Murthy, they are
Y.S. Murthy.
private persons.
My lord, I have specifically about my retention. So also my petition paragraph 7, my Y.S. Murthy is bedridden now. She has
Why?
bedridden. She is old. He was not present. But manipulating that's in my retention, I have raised my objection also in petition. So, page 23, my lord, page 23. And also
23, another
one-
person was
one-
also nominated, but he has not come. That cannot be.
That's it. Also, and also Ashok Kumar Panigi was nominated. He is also Ben Stoker admitted at Bangalore Hospital. Page 23.
Collector may also get admitted in a hospital.
No, on the date of health committee.
Not in good taste, Mr. Counsel. The petitioner has filed the present writ application in the nature of public interest litigation, raising grievance against biennial revision of market value of the immovable properties under Gajpati district, mainly on the ground that the committee responsible for considering biennial revision constituted committee had not been duly constituted in accordance with Rule 37 of
The Odisha stamp rule.
Odisha Stamp Rules 1952. So stop. It is the petitioner's case that the said provision requires presence of two public persons to be nominated by the chairman, to be the members of the committee. Stop. However, the two members of the, in the meeting dated
2nd February 24.
2/2/2024, two persons, namely Virja Prasad Patra and Y.S. Murthy, have been shown to have participated for biennial revision of benchmark valuation for the year 2024-26, in fact, they were not present. In fact, they were not present. So stop. Accordingly, he contends that the decision taken by the said committee cannot taken in such meeting cannot be said to be legal. Stop. Next. The submission advanced on behalf of the petitioner that the committee was not properly constituted has no substance. Full stop. The rule required presence of two private persons, one of them being an expert valuer as nominee of the chairperson in the committee. Stop. Such two persons were included in the constitution of the committee. Stop. The submission that the two private persons were not present in the meeting on a particular date is a question of fact which need not be gone into in the present proceeding under Article 226 of the Constitution of India in a public interest litigation. This application has no merit, which is accordingly dismissed. Not present जहाँ पे है. We however notice that the said two that signatures of the said two persons are present on the minutes of
Matter is fixed at 2 p.m. No, item number 55. Item 12 is not similar. Not similar. Yes, similar. No, that is education department, all circulars, and let him satisfy. Yes, my lord. This is a health department, my lord. They have been regular items. Yes, my lord. Those batch of cases relating to regularization of Shiksha Karmi, they have challenged that virus of that rule. Here, my lord, they are contractual MPHWs. They are regular by set of a one resolution. Now they are challenging another rule, my lord. No, my lord. Similar matter 31170/23, my lord. That is in that group. Some matters are different. They are tagging that.
They can be excluded.
Yes, yes.
Similar matters have been tagged.
But my lord, challenging the same rule, my lord. We are challenging the same rule of 2022, my lord. My lord, kindly have a glance, my lord.
That is relating to education department and
Yes,
they have challenged that virus of repeal.
Yes, my lord.
Of that 2013 rules, right?
Yes, my lord.
You are
Here,
in health and family welfare.
MPHW, they have been regulated by virtue of a resolution in 2019. They are no way connected with the 2013 rule. Lordship, kindly have a glance at that rules which you are challenging, my lord. Annexure 8. That is page 74. And my lord, it is for all contractual set of employees, not for education only, my lord.
Come to paragraph 1.
My lord. But he was not appointed in accordance with this rule. Your lordship, his appointment order is of 2011. This rule has come into force on 12 November 2013. Now we have repealed this rule. For a moment, kindly have a glance at Annexure 9. The SOP issued basing on these rules, my lord. That is page 76.
They are challenging the virus. See, if you confine,
yes, my lord,
your prayer to the validity, question of validity, then the matter is different. Otherwise, there are 31 petitioners. All of them may be having different cause of actions. So they should have filed separate petitions. Otherwise, yes, if you confine your prayer to that, the matter may be different.
Your prayer number 5?
My lord.
You come to prayer number 5. The contracts may be different, the dates of contract may be different,
My lord. My lord, we are all appointed in 2011, my lord.
maybe.
But we are appointed on the same gradation
We do
list
not know.
and, my lord,
Contractual appointee.
yes, my lord.
So you must have executed contracts with.
Yes, my lord.
Individually.
Yes, my lord.
So the terms and condition, we do not know.
Well, the terms and condition are the same.
Then your prayer 5 and 6.
Your lordship, see prayer 6, if that gradation list will be passed, then who are to be affected, they are to be made parties here.
That's why.
No, we are being affected because, my lord, the juniors.
Mr. Counsel,
Yes, my lord.
you may be affected.
Yes.
We may not be affected, we don't know. But when 31 petitioners have joined together,
Yes, my lord.
then the principle is that if the matter can be decided by one stroke of pen, then it's all right. But if the like validity of law, that has to be decided by one stroke of pen, I mean whether they are valid or not valid.
Yes, my lord.
Then you may have common cause of action. But since you have your contracts are different, your period must be different. How can all the persons join in one writ petition?
My lord, these are all contractual employees appointed prior to 2013 rules.
All employees are employees of the state government of Odisha.
Yes, my lord.
Therefore, they should file one writ petition raising all the grievances relating to disciplinary proceeding, pensionary benefits, payment of, because they were appointed by the same government. This is your plea. Is this a plea?
No, no, my lord.
Therefore, there is multiplicity of cause of action.
My lord, all these petitioners, my lord, belongs to one department, my lord, were all appointed on the same date, in 2011, my lord. My lord, our case is, we are appointed 2011, and the candidates were appointed after 2013, my lord. Their services are being counted. Their contractual 6-year service has been counted in the regular service, and they are getting 6 notional increment. Here, my lord, we are getting nothing, my lord. And
So
juniors,
according to you, your case is covered by 55.
yes, my lord.
So we will hear your case after 55.
Yes,
Yes. I'll file counter here also.
Yes, my lord.
8 weeks time is allowed for the state to file counter affidavit. This matter on 8 weeks.
Item number 13.
Obliged, my lord.
Lordship's order is complied with.
Both the cases
As reported.
all complied.
You stated at the bar that this court order, violation of which has been raised in the present contempt application, has been complied with in both the cases.
Yeah. Both the cases.
Item 14.
In item number 14, pursuant to lordship direction, the director has passed an order, instructing the BEO, block development of block education officer to make payment. And I pray lordship grant me 10 days time so that we can make pay.
As requested by Lieutenant AGA representing the contemners, let's this matter on 2 weeks as to report full compliance of this court's order, violation of which has been raised in the present contempt application.
Item 15.
The order dated 8/2/24 plus 27 has been complied because against the honorable single judge, they've come and writ appeal was allowed with the modification that I must be given appointment because I am the writ petition. But till date, my lord, despite disposal of the writ appeal, I have not get in my appointment.
Where is the order?
My lord, page 27. Effective part of the. Earlier, another case was there that has been quoted here. In same light, it has been disposed of. That quoting person was the order. Shall I read, madam? Having heard on counsel for the parties and after perusing the material available on record, it appears that the appellants have already been regularized in service and their services have been protected, and since the judgment is passed by the only single judge, setting aside the order of termination of the respondent of 4 and directed them to reinstate, question of keeping the matter pending would cause inconvenience to the respondent of 4 in both the appeals. Hence, the writ appeals are disposed of by modifying the common judgment of the single judge to the extent that respondent 4 in both the appeals be reinstated in service and would be granted all the consequential benefit due and admissible to them without affecting the right of the appellant, which they have upon the process. So I am to be I am the respondent 4 in that appeal. I was the writ petitioner. But though the order was passed in February, my lord, it has not been complied with. The writ petition was disposed of on.
No, we are in April.
Pardon?
How contempt is made out?
Yes. This order has not been complied with.
All right, they will
But-
comply. It is not that they are not complying with the order.
No, they're not
It is
giving.
only less than 2 months you have filed this
Yeah.
contempt application.
Not because a writ petition was earlier disposed of. It has been now modified. Other of the writ appellants are in service. We are not quarrel now. Only thing we have to be reinstated because our termination is set aside.
All right, but this order was passed on 8/2, and
My lord.
when did you file this contempt application? Should not have been done so fast. When did
They
you
are-
make your representation?
They're not in service, my lord. That is kindly see their anxiety.
No,
They're
no,
terminated long since.
sorry.
If my friend will take instruction, if they can
No,
be given
no,
appointment.
Not written. The petitioner in the present contempt application has alleged disobedience of this court's order, non-compliance of this court's order dated 8/2/2024, passed in WA number 545 of 2023. Stop. When counsel appearing on behalf of the appellant has submitted, a petitioner has submitted that despite the said order of this court, the appellant has not been reinstated. Stop. Next, the order of this court was passed on
8/2, my lord.
8/2/2024. Stop. When did you file? The slightly more than 2 years, 2 months
2 months.
after this said order was passed, the petitioner has filed the present contempt application. Stop. The order does not stipulate any time within which it was to be complied with. Stop. In our considered opinion, no case of deliberate disobedience of this court's order is made out. The contempt proceeding stands.
May answer, Mr. Man. Kindly turn to page 23. Before the single judge, we have filed a contempt because by that time there was no stay. The honorable single judge has decided on 27/1/2023, directing them to 2 months' time to comply. That is why, because it is modified, I have filed it here. That may kindly be taken. Page 23.
Rule and counsel appearing on behalf of the petitioner has submitted that the learned single judge disposing of the writ petition had granted 2 months' time for reinstatement, reinstatement, we are not satisfied that any non-compliance of the said order amounts to contempt of court.
7/1/2023. The single judge has filed contempt number 7823/2023. There, 2 months time. The writ petition was disposed of directing reinstatement.
Yes.
There was no period.
No, that there is 3 months' time.
3 months.
Thereafter, I filed the contempt.
Thereafter, contempt.
Writ petition disposed upon
In
23/8/22.
contempt for 2 months.
2 months further time was allowed by this honorable court, by the honorable single judge. 2 months time. Thereafter, there was no stay of this order. They filed a writ appeal. So writ appeal, because the writ appeal was pending, so we could not proceed further. So writ appeal was disposed on 8/2/22. That is why I came before this honorable. Because the order was modified, I could not go to the single bench. That is the plight. Now, if my lord will sit there, they will be remedial.
Well, disposing of the writ petition, while hearing another contempt application, in the contempt application.
Yes,
2 months time,
before
hearing
the-
another contempt application had granted 2 months time for implementation of the order passed by the learned single judge in the writ proceeding.
Yes.
Stop. So there it is. The court order can be said to be contumacious, or the order can be said to be deliberate. Contumacious in view of contumacious for the present. Stop. We dispose of the present contempt application with an observation that it is expected that the contemners shall comply with this court's order within a reasonable period of time. Is that enough?
That will do.
Is that enough, Mr. Samantha?
Yes, well, I will get.
Any time, my lord? Kindly.
No time. Let them not comply. We will see.
Again, there will no time if we cannot
Just-
come, my lord.
Just.
Terminate an employee from 22, my lord. Kindly. Connected case. In both the cases, same order.
Taken time for some instruction, my lord, in the order dated
May I
10th
come in, my lord?
April 24, my lord. And today I have received that writ appeal number 205123.
It has already been decided by lordship. And this writ appeal is against the order of the honorable.
Say, I will examine because my case is different, my lord. So lordship may let this matter be taken up for capture, my lord.
No 4 week after. Why should we allow these matters to remain?
Any other day, my lord, be taken up, my lord. Because I have not gone through this takeout.
Where is the order?
The writ appeal 205123, my lord. I have not gone through this, my lord.
Which?
I will examine that.
Let us see the order. What will you examine? You cannot.
My order is, my lord, annexed to 1, my lord. And where I was not the party. In similar matter,
We have examined section 22 of the NGT Act.
yes, my lord.
And we are one with the.
So what happened, my lord, in the tribunal, my lord, in the Green Tribunal,
Single judge.
we were not the party, my lord. We were not made party in the tribunal, my lord.
Yes.
We are not party, my lord. We have not given the opportunity of hearing. So, your lordship, in that similar matters, the coordinate bench has allowed this petition in another application, my lord. This is the order in the writ petition number 2673023, my lord. They were allowed and sent back to the petitioner to remedy, to take the.
This writ petition cannot be maintained. That is the only thing. my lord.
I will examine.
What will you examine? That has been decided.
Let me give opportunity, my lord. I will go through this.
Tomorrow, unnecessary.
And that day your lordship will dispose on that matter. I will
Tomorrow we will take.
tomorrow, my lord. Monday your lordship.
Sorry.
Tomorrow, my lord. I
No.
have a,
Tomorrow.
my lord, Monday your lordship.
Sorry.
Item 17.
17, my lord, there is a delay of 38 days only in filing the appeal because of the.
Yes, where is that? IA number?
My lord, 726.
Let flag B, my lord.
IA number 726.
My lord.
Yes, who is for the other side?
State is there. My friend is the.
I am also for appearing for the private opposite parties.
So you don't know objection? Excellent. And learned counsel representing? You are representing?
Five. No, respondent of 5.
Respondent number 5. Who are other respondents?
Statement.
Opposite party numbers. Learned counsel for the petitioner. Learned counsel, learned AGA for opposite parties number 1 to 4. And learned opposite, your respondent, sorry, respondent. Respondent. And respondent number 5. Stop. There is delay of 30 days.
8 days.
38 days in filing the present appeal. Stop. Considering the explanation put forth in this application seeking condonation or delay, the same is allowed, comma, the same is allowed. First of the delay in filing the present appeal stands condoned. Stop. Unless this matter as press case. Press case, you are.
My lord, may respond number 4 is governing board. Respond number 4 is governing board.
The private party.
Governor,
Private
sub-collector, sub-collector.
My lord, 1 to 4.
Sub-collector.
Delay 4 days. 4 days.
Item 18.
May I please, my lord? My lord, IA number 309, there is a delay of 23 days.
In that case, the lordship may direct me to serve a copy of the appeal memo. Because
3 days delay.
no, appeal memo. So for the appeal memo.
Appeal memo,
Yes,
Give him-
appeal memo. The lordship can direct for you.
give him.
Sita the condon. I have nothing to say about condon. So for the appeal memo, main merit case.
Yes, I will serve it. Yes, it is there.
My lord, at IA number 309 of 2024, there is a delay of 23 days. Your lordship.
Yes, who is on the other side?
Well, the housing board, my lord, actually is a
Housing board.
contesting party.
Why are they not having a standing council here? They don't have any standing council.
Not have it.
They have a panel.
They have a
first,
pan-
but They don't appear. Only after on receipt of notice there.
No, in this case, we'll issue notice. Limitation. Issue not registered and speed post.
Item 19.
May I speak to lordship? I am for the appellant.
Which item?
19.
So this is a petition writ appeal. So we are. So this case has been filed for condonation of delay.
How much?
There has been a delay of your lordship, 10 months and 15 days.
350 days delay.
10 months and 15 days. So
300? How much is left?
10 months and 15 days. 10 months and 15 days, your lordship. I feel the appellant was suffering from type 2 diabetes and hypertension, and was confined to bed almost all the time. So he has been treated by the doctor.
And where is the impugn order?
In order to annexure 1, annexure A, your lordship. Annexure
Section A has been passed by Odisha Administrative Tribunal.
Annexure A.
No, right.
Like this one.
Those
It
converted.
has been passed by the Lord Single Judge VP Satpathy.
Right.
VP Satpathy. So awarding a compensation amount of 5,000. Finding the state respondents responsible for violation of the fundamental rights of the appellant, that is Article 21, for deprivation of for livelihood and invidious discrimination in giving appointment to other civil engineers and depriving the appellant, Your Honor. Your Lordship. So this street appeal has been filed only on the limited ground of quantum of adequacy of compensation amount, Your Lordship. Had the appellant been appointed in the year 93, 94, Your Lordship, you would have been gone to.
So you want us to enhance the compensation amount?
Amount to be raised, Your Lordship.
Sorry.
To be raised from 5 lakhs to, I have demanded actually 60 lakhs.
So file.
I have given a charge.
You could have withdrawn the writ petition and filed a suit. There you could have proved the damage caused to you. Not
Right, Lordship, it is a matter to be decided. Actually, it is a tortious, almost tortious liability. It should have been decided by the civil court. I could have approached, but since I have approached this honorable court and an order has been passed.
How much compensation should be awarded according to you?
Your Lordship, I have actually claimed 1/3 of the, that is 60 lakhs.
60.
I have actually appended.
You want 60 lakhs?
Your Lordship.
And why not 4 lakhs?
Your Lordship, 5 lakhs has already been granted.
No, there must be some, there must be some basis for determination of amount of compensation. So why not 4 lakh? Why 60 lakh?
Kindly, Lordship, see Annexure B attached to the.
Is there any basis for computation of amount of compensation?
Your Lordship, Annexure B. Kindly, peruse Annexure B attached to the.
What is Annexure B?
Memo copy.
That
is Your Lordship, chart showing an estimated financial benefits, service benefits, that is the appellant would have been has been appointed in the year 94 as tribunal engineer and went on earning her promotional pay on promotional post till a superannuation on 15.
Sorry. The IA number 302 of 2024. This appeal is barred by limitation, and accordingly this application has been filed for condonation of delay of 318 days. Stop. The petitioner had preferred an application and preferred an original application before the state and Bihar Odisha Administrative Tribunal, giving rise to OA number 2966 of 2016, which came to be transferred to this court upon evolution of the tribunal. The case was registered as WPC number, transferred case was registered as WPC number, WPC OA number 2966 of 2016, which came to be disposed of by a learned single judge of this court by an order dated 15/2/2023. which is under challenge in the present writ appeal. The appellant had filed the case for quashing of an order dated 6/12/2016, bracketed annexure 3, with a further prayer to direct the opposite party number 3 to consider his case for appointment as stipendiary engineer, bracketed civil, against a vacancy that had arisen in 1993-94. Stop. Learned single judge, after having examined the merits of the case, concluded in paragraph 7.4 as under. 7.3 and 7.4.
7.5, your lordship.
After having held as noted above, then single judge concluded that petitioner was entitled to get compensation amount of rupees 5 lakh. Stop. In the present appeal, the appellant claims that more amount of compensation ought to have been granted by the learned single judge than what has been granted. Stop. Next. Be that as it may, we have perused the explanation put forth in this application seeking condonation of delay. So, the appellant, according to the appellant, she was suffering from diabetes and hypertension, and therefore she was advised bed rest. And thereafter she had been under regular treatment. Stop. The explanation so put forth by the appellant for condoning delay does not appear to be satisfactory. So stop. IA number, this application is accordingly dismissed. Consequently, WA number so and so also stands dismissed. Yes.
Item number 20.
May I please, your lordship? My lord, the delay of 16 days, your lordship. My lord, I have taken a plea of having dysfunctional uterine bleeding, for which reason she couldn't
16 days.
16 days, your lordship.
Yes. Can we conduct? IA number? Heard so and so.
1257.
Delay of 16 days. 1257. Delay of 16 days in preferring this writ appeal is condoned after having
IA 1257 of 20.
stands condoned in the interest of justice and in the background of the explanation given in the application seeking condonation of delay. Yes. It will come as harassment. It will be listed for admission.
May I pray if your lordship permits my lord for tomorrow, because this is a matter relating to eviction, where the land rights pata has
Make
been
a mention tomorrow. It will not be taken up tomorrow. Ask your junior to make a mention tomorrow.
obliged.
Item number 22.
Wait, please, my lord. The matter was before your lordship's day before yesterday. To recapitulate it, my lord, this is a matter where a ST lady had married a non-ST.
Yes, that was the question.
And my lord, your lordship saw on the other day the regulation and that rule, which was amended in 75. But I examined, my lord, the transaction was also earlier. So, and I am not going into that clarificatory amendment, other things, but I am greatly obliged that your lordship gave a hint about the change of caste by marriage. This has been dealt with in that Valsama case, which was considered by the Bombay High Court.
No,
in
not
the
Bombay, subsequently Supreme Court.
Yes, my lord. Bombay High Court in the full bench has observed certain things which was approved by the apex court, my lord, in detail. In that case of, I have also got that apex court judgment, my lord, for my lord. That is, in the case of Ramesh Bhai Dabhai, that is 2012. Three SCC 400. Second judgment, my lord. First is Bombay High Court because I found that Bombay High Court observation has been approved by the apex court in paragraph 34 of that 2012 SCC. Paragraph 33 they are quoted, and thereafter in 34.
Medical admission. Medical, Valsama fall related to admission in medical.
My lord. And your lordship will also find the other judgment in 2018. There also it was said that by birth only, it is not by the marriage. One will, and here the legislation is to see that the land of the scheduled tribe will not go to others without competent authorities' permission.
Where is the previous law?
My lord, previous law, that explanation was not there.
Where is that? Could you get that? We need to read that.
That was the original regulation, my lord. Previously, this explanation was not there, my lord.
Forget explanation. What is?
I am only.
Could you get that Supreme Court's decision? Earlier Supreme Court's decision, the
96, my lord, Valsama.
No, before that.
Before
Long
that.
back.
It might be 84, my lord, or that.
80?
That might be 84. I have not got that
70,
citation.
I think.
Citation for your lordship. Since I found that Valsama has been considered at length.
No, Valsama.
2012.
In Valsama, they must have considered that that had arisen from Jharkhand. That case had arisen from Jharkhand. Must have been taken.
I will get that judgment after lunch, your lordship. I will pass it on to your lordship. We will search in the meantime.
Oh, that judgment must have been considered by
Valsama, my lord.
in Valsama. It was an election petition. It was an, yes. It is there.
Service.
In that case, probably a woman had contested an election against seat reserved for
Scheduled
scheduled
caste.
tribes on the ground that she had married a
My lord,
tribal.
I will pass on that judgment, my lord. I will search it and give. Before rising of the court, I will give it that. For these three judgments, your lordship may kindly note that in the Bombay High Court, relevant para is para 9 to 12.
Bombay High Court must have taken into account.
Full bench judgment.
That is the leading, that is the. Well, some and other cases have been noticed as they related to that judgment related to medical admission. That is a very famous case. Let us see the
Bibigiri case also.
Let us see the provision, statutory provision.
Bibigiri case also 1960. Bibigiri D. Suridwara.
Maharani something. Case, the name of that case was Maharani. Yeah, something. Oh. Yeah, the first case on this point was of Jharkhand, of dispute arising out of that, not Jharkhand, Bihar, it was then Bihar. Where is the act? Where is the provision?
My lord, Regulation 3.
Regulation 3 unamended.
Unamended, my lord, I just have a.
Regulation 3.
Yes, my lord. Notwithstanding anything contained in any law for the time being in force.
Those judgments will apply in this case.
3-1.
Member of
Also, we have also under ORV Act, some circulars and executive instructions also in which
Reservation.
marriage will not change the
My lord. That is for service, my lord.
service law.
Subsequently, this has been
That
taken.
is the most important decision. You should find out.
My lord.
It involves a question of law.
I'll get it, my lord, with your lordship. Tomorrow also, will be convenient.
As requested on behalf of the appellant, list this matter tomorrow.
Item number 23.
Please examine this aspect. It's very important because it's the language of the provision says scheduled tribe. So we will have to read that as scheduled tribe. And then the question will arise as to whether after her marriage, the caste status can be said to have changed or not. The courts say no.
Okay, that's.
So this is. Yes.
Item number 23.
Please, my lord, this is that matter where those 444 UTPs were there. Subsequently.
Oh, yes. Yesterday we could not take up the matter.
They have reduced it by about 80. Day before yesterday, they had reduced it by about 80. And it was then he was supposed to. Is there on?
Yes.
Hello, Namaskar.
Yes, Mr.
Your Lordship, 75, around 80 UTPs have been released. So now the figure is 369. And Your Lordship, if Your Lordship permit, then we will have another report from the DLSA after 2 weeks regarding the status of the UTP.
So do you expect some improvement in the meanwhile?
Yes, ma'am.
360 prisoners. Yes, any other option?
My lord's own order dated 12th of April records the Supreme Court guidelines. I don't know whether that is being followed. In fact, that was the ground on which my lord adjourned to today, because if my lord would see paragraph 2 of that subclause 2 of para 10, which has been extracted.
Yes, which order 5-4?
12-4. Order number 53.
12-4.
My lord's own order.
Yes.
Quoting the Supreme Court decision. And then para 10, subclause 2. If the accused is not released within a period of 7 days from the date of grant of bail, it would be the duty of the superintendent of jail to inform the secretary whom a depute. So on this ground, and then my lord saw the entries made by the report. Now, some of those entries, these people have been released way back in 2021. Some of them are in 23. So it's been almost 4-5 months and these people are not yet been released.
Can you tell us whether you are following the direction 1 and 2?
Yes, my lord. Our PLB and jail visiting lawyers, they are visiting the jails and interact with the UTPs and apprising regarding
the first direction is that the court which grants bail to an under trial would be required to send a soft copy of the bail order by email to the prisoner through jail superintendent on the same day or the next day. Whether this is being complied with or not.
No, my lord. The jail superintendent, we are collecting the figure from the jail superintendent actually, and from the court also.
All right. Right, we will take up the matter tomorrow. All right.
So similar directives below that, that is also important. Within 7 days, if he is not released, that has to be immediately taken up. So if
Right,
my
we
lord
will
would
take up
see,
with the judicial officers. I'll take up this matter with the judicial officers first and then.
the table which they have been kind enough to give, that would reflect how
it is being moved, because there my lord would see that some of the offences are also petty offences. It is not that the offences are serious. Some of them are 379. And then my lord would see this is more prevalent in the tribal belts of the state. So at least there, they should be more proactive.
No, I'm going to address the judicial officers today. I'll convey to them. And then tomorrow we can.
We are all grateful. There was one more issue that is vis-a-vis the state government. If your lordships would allow, my lord Justice Raman knows there are 2 jails which we are not able to manage. That's
order dated 12/4/2024. 12/4/2024. And the interaction will be disciplined. Today, I'll myself be communicating this thing to the judicial officers, the district judges. Let us see what happens.
We are all grateful to you.
Item number 25.
In item 25, the government on last occasion served a copy of counter affidavit to your lordship. I'm already on the verge of completion of the rejoinder affidavit. If you lordship give me 1 or 2 weeks time, I will file the rejoinder affidavit.
Yes, sir. I filed some sort of copies of that by the control.
Learned counsel for the petitioner states that a copy of the counter affidavit. Copy of a counter affidavit filed on behalf of the estate has been served upon him recently. Requires consideration. Stop. List this matter on. And 2 weeks.
2 weeks, your lordship.
2 weeks. Stop. The petitioner shall be at liberty to file rejoinder in the meanwhile.
So there are 3 matters, in fact. The second matter actually is a single judge matter. Now we're connected with this one. Third matter is the government has not filed counter. If they adopt the same counter,
I saw the copy on my laundry senior today itself.
They adopt, you should indicate they adopt the same counter.
Mr. Samantal and counsel and AGA has stated that the state adopts the counter affidavit filed in WPC number 28787 of 2013 in which case?
2886.
Yes, sir.
In
But the 2886
the
third matter.
Third
matter.
Third matter.
2886 of 2014.
The second item is survey and settlement.
Yes, sir. All right. That has been adopted in this.
Right. And the interim order to continue. In my case, there is an interim order.
Interim order shall continue.
Item 26.
And the second item is not connected.
Sir, second item is single well matter.
Single well
Solvent Settlement Act.
by wrongly it is there.
Oh, it is wrongly there.
Right.
12561 of 13.
It has been jointly stated at bar that WBC number 12561 of 2013 has relates to survey settlement and is not connected with the present matter. Stop. Let WPC number 12561 of 2013 be delisted and placed before an appropriate bench.
Item number 26.
This matter, your lordship had heard us on both sides that allotment of IDCO property. Your lordship had heard and said that it will come back. That only your lordship, just to recapitulate, your lordship, annexure 12 is under challenge. That means cancellation of an allotment of a property made in favor of the petitioner for establishment of an hotel. In annexure 12, their reason is that you have violated clause 16. I had brought to your lordship's notice clause 16, after which the lease deed was executed. So my submission was, after execution of the lease deed,
that clause does not survive to be considered if the lease deed which will be adopted. Now, upon hearing all the councils, your lordship had initially passed an order directing them to file an affidavit. Just your lordship, I'll just, so pardon for my repetition, just 2 lines order, 19/1/23 order passed by this honorable court. It is seen that amongst other grounds, the petitioner contends that it was not in a position to complete the civil construction and start commercial production on the plot in question without NOC from IDCO. In paras 9 to 11 of the writ petition, averments have been made in this regard, which have not been replied to at all by IDCO in its counter affidavit. There is only one line in para 12 of the counter affidavit which tries to deal with 9 to 11 together without dealing the Lord Counsel seeks leave to file an affidavit. An affidavit was filed before your lordship. Now your lordship sees that affidavit does not reply to our averments, our allegations made in 9 to 11. Your lordship may see that affidavit, just 1-page affidavit. Additional counter affidavit filed on behalf of opposite parties to it. Get the page set up. 96, page 96. Page 96, paragraph 3, in reply to averments made in paragraphs 9 and 4, it submitted that the plan of the petitioner was approved by the BDA, but thereafter the petitioner does not proceed to start any construction, which is nothing but violation of clause 3 of the lease deed, wherein it has specifically stated the lessee shall have to start civil construction on the allotted property within 6 months from the date. In this paragraph, the petitioner has admitted that it got techno-feasibility report on 3/9/2012. It will be noted that techno-feasibility report annexure is a report by a private consultant added by the petitioner. This is the only answer which they could give. Your lordship sees the debt chart which I had given. It is clearly, we have to proceed from the point where BDA had gave the, because till that time I could not have started the construction. BDA gave the permission on 15/10/2011. Now 15/10/2011, on 3/11/2011, that is about less than a month, I applied to IDCO for supply of documents for getting feasibility report. Otherwise, I cannot start construction. And on 3/9/2012, I got the feasibility report. So, and main point which I had urged before your lordship says that when after getting the techno-feasibility report, I applied to the bank that you give me loans. The bank said that you get NOC from IDCO. And NOC from IDCO, after I applied to IDCO that you please grant NOC because the bankers want it, they could have rejected. Now they say that for 1 year you did not do anything. They could have said that no, 1 year you do not do anything. Although I said that I was waiting for the techno-feasibility report. Even if that is not, you could have rejected that. But they forwarded my prayer to their head office to supply NOC. And within less than a month, they cancelled it without giving any reply to it. This was the crux of the matter. Now, your lordship sees in the lease, clause 5, this is lessee with the previous consent in writing of the lessor can assign transfer his interest. And it has to consult with the bank. So I had consulted, and the specific query made by your lordship was to reply 9 to 11. And 9 I have given that I have applied for techno-feasibility report in time, and the document was given after 1 year. Where is my mistake? They have not denied.
So what do you want to do on that plot?
Hotel. I have paid up to date. This is for your lordship's information. Till today, I have paid all up to date debts. Dues.
Where is the that land located?
Municipal.
Can you complete it now?
Permanent? Yes, yes, I can complete. I offered to them. There is a judicial order passed by your lordships that I will take it on the present price also, if there is any impediment. That also they gave a reply that no, will not. But if they insist on a pound of flesh, my lord, I can't go. Lord, I have given I have taken every step, and without NOC, and your lordship knows this is the judicial note of it. I would request your lordship that unless I get a loan from the bank, I cannot proceed with the bank is ready to give. Only the NOC is to be given.
Yes.
Yes. I prepared a small list of dates. Your lordship may kindly go through this list of dates to just ascertain the conduct of the petition. My lord, these are industrial plots which are given by IDCO with the intent of industries infrastructure development in the state. The state government, my lords, gives land to the IDCO on 99 years lease basis so that industries can be set up there. IDCO thereafter develops the land into industrial plots, appraises the projects of the entrepreneurs, and on satisfaction of their project report, they allot lands in the industrial shed. So, my lords, way back on 23/4/99, 2 acres of land were allotted in favor of the petitioner for the purpose of setting up of the hotel. Now, my lords, this, as my learned senior has already pointed out, this now, my lords, 2 acres of land at 20 lakhs in Bhubaneswar today, even 1/50th of that would not be available. So on 5/9/2002, that is after 3 years, because the lease, the allotment letter specifies that within 6 months you have to complete the construction, and within 2 years you have to go into commercial production. So he did not do that. The land was remained unutilized. So in 2002, a show cause notice was given to him. So, and thereafter, since their reply was unsatisfactory.
But whether any fact is required to be looked into now.
Yes, my lord.
Before 7/12/2010. When the lease deed was executed.
Yes, my lord. Now, my lord, for that purpose, I just show to your lordship that after the lease was executed, it was on the condition that his cancellation was revoked and the lease was executed with the condition that he would implement the project within 1 year, failing which the order of cancellation would be re-invoked. That was the condition, and to that effect, an undertaking was given by him. Now, even after 2012, he did not, after the execution of the lease notice, we waited till 2013. Nothing happened except for construction of the boundary wall. Nothing happened. A second show cause notice was given. On the second show cause notice, thereafter he comes up with a techno-feasibility report. Now, this techno-feasibility report has ought to have been given prior to 1999. That your project which you are proposing to put up is a viable project, and since you have satisfied
whatever may be the reason.
Yes,
the state court on 13/9/2010.
Yes, madam.
Had revoked the cancellation.
Cancellation subject to the condition that within 1 year you will have to.
So therefore, everything what was done or not done by the
is deemed to have been condoned. Is deemed to have been condoned.
Right.
Now, after 2010, up to 2013, because the timeline under the covenant was 6 months for completion of project.
Therefore, you were required to say, and that is the reason why the court had directed you to file a counter affidavit specifically dealing with paragraphs 9 and 11.
Yes, madam.
So after 7/12/2010, when the lease deed was executed, what did he do?
He did not do anything. He did not do anything.
He must have applied for loan. He must have. He is saying he sought for your.
He waited for a techno-feasibility report post 2010.
What is wrong in it?
The techno-feasibility, as I indicated at the very inception to your lordship,
that all these lands, industrial plots are given after testing that the project is feasible. Because unless and until a project is feasible,
That
the
was in
industrial plot will not.
1999. That had happened in 1999. Now in.
So, my lord, when he asked for revocation, he ought to have got the project appraised again before asking for revocation. Why did he wait for revocation and then thereafter went for techno-feasibility? Let us assume that he went for techno-feasibility report post 2010. Even then, did we have to wait for 3 years, my lords? When the timelines are specified in the lease deed.
He was waiting for loan. This is his case.
No, my lords, he was not waiting for loan. He went for loan only in 2013, post the techno-feasibility report.
No.
He went for loan only in 2013. That is the letter under Annexion 9 at page 56 of the bank. This is January 2013.
Consider it.
My lords,
in view of the offer.
But yes, my lords, he has made a very fair offer that he is ready to pay the present market rate. Let him make a representation to that effect before the CMD. He will definitely favorably consider it because, my lord, IDCO wants all entrepreneurs to flourish.
We understand.
Industry to grow.
We understand.
That is our concern.
Right.
So your lordship may observe that he will make an offer to the IDCO that he is willing to pay the current market rate. And the managing director will deal with it within a period to be specified by your lordship.
Your lordship, but they have already filed an affidavit to your lordship's order. Your lordship had made that, passed that order also. That you
We cannot on our own volition say that we
No. Well, your lordship passed an order. They filed an affidavit, no, will not do. So now my learned friend says that it can be done.
You said, yes.
I am saying that from the beginning. I am saying that. I am prepared to give the
without entering into the controversies relating to the failure on the part of the petitioner to establish a hotel on the land allotted by INPO. Senior counsel representing the petitioner has submitted that the petitioner is ready to pay the market value of the plot in question. If the IDCO agrees to revoke the cancellation of allotment. Stop. Next. And senior counsel representing the IDCO has submitted that the managing director IDCO shall consider if any such proposal is made by the petitioner. Stop. Next. List this matter on 4 weeks. Stop.
I'll make a representation within 7 days.
Yeah, this is what we are going to say. Let representation / proposal be made by the petitioner to the managing director. CMD within 1 week from today. Stop. The court expects that the managing director shall take a decision on the petitioner's proposal within 2 weeks thereafter. 2 weeks enough.
Your lordship said market rate, that is government rate.
Government.
Benchmark value. Benchmark value. Your
Because
lordship may indicate benchmark
market
value.
rate-
We can say benchmark value.
Well, yes, your lordship can say benchmark value.
Benchmark value.
Interim order.
Interim order shall continue in the meeting.
That item 25, you lordship heard the matter. 27. The date chart your lordship wanted, actually it is, your lordship, the single judge, honorable single judge order is to be confirmed. I also agreed the other day, your lordship, that recognition of the school, your lordship remembers 2001 and 2 they have given. We wanted retrospective. Only the date chart I can give.
Please give the date chart. Or something.
Yes, but thereafter, if matter will be taken
Then
up.
thereafter also there is another case fixed at 2 p.m. Mr. Nanda's case.
So there are 3 cases today.
So I think also the Lord Advocate General also wanted time. He said, so he also fix up another date at 2 o'clock. That will be better so that this matter will take some time. It can be disposed of.
All right. So have you prepared your notes?
Yes, sir, I have
Everything
already
is ready.
I have prepared. I'm ready today also, but this is the
No,
problem.
no, the written notes.
Yes, everything.
6th May.
Permits, we can file it for my lord's convenience.
Please do it.
We can file it, that convenience compilation with note of citation. We can file for my lord's.
Yes.
Meanwhile, we'll
That
I
will be
think it will
helpful.
be better. If you also will fix up at 2 o'clock on Wednesday, coming Wednesday, that will be, I think.
No,
that will be
Wednesday, there's
First way.
1st May.
1st May.
1st May.
Lordship, may pray for lordship, can it be any other date except 1st May, my lord? Because my lord, Senior Advocate Pitambar Acharya is leading me in this matter, 22 of the writ petitions. He is badly held up on 1st May, my lord, 30th and 1st May.
Any other date you also fix up before 1st, I think on Tuesday or Monday. Any date convenient to us. Basic council, there will be some problem somewhere. But we should begin it, and if there will be some delay, then.
So the first May, my lord, civil will start. Then
Yes, that can be.
Lordship, any other date except 30th and 1st May, my lord, may I pray?
Let it be on 1st May. We will accommodate you.
Grateful.
That will do.
1st May.
And another matter which has not
2
been
PM.
listed, WPC 26805 of 2023. I'm giving this leave. And another matter is item number 10 also, same matters.
Item number 10. Matters are bit.
Same matter. I'm giving the number so that all the matters can be listed. And one counter they have filed. I hope that they will attach that counter to all cases. In the first matter, they have filed the counter. And I think if they will adopt in all cases, that we have nothing to say.
and also we have prepared a preparation of the note that will be also fine.
So just formulate the points which are to be addressed by you and
Yes,
later
yes.
by us also.
Right.
Item 30, man. Item 30, man. Since the other matters will take some time, will not may it be taken up on some other day, man.
30 will take some time.
Item 30, man.
That is fixed for 2 p.m.
And
Not. But still, let the matter be taken up tomorrow. If it is not taken up today, and then it
The
will be-
appellant in this case, my lord. I am for the appellant and my lord seniors for the bank.
next week, man.
Next week.
let it come tomorrow.
Tomorrow.
Or Nigo, as requested on behalf of the parties, list this matter on.
No, maybe draft to tomorrow.
One
Tomorrow,
week.
let it come tomorrow.
1 week.
Tomorrow.
1 week, 1 week.
Matter fixed for 2 p.m. Item number 21.
My lord,
21.
yeah. I have prepared a small date chart. I will just place that date chart before I start my argument.
Yes, yes.
Name. Only relevant dates I have mentioned, only relevant dates, not all the dates involved in the case. 21/9/1970, the successor in interest of the ex-intermediary Nityananda Bharati filed an application under section 6 and 7 of the OA Act before the Tahsildar Cuttack for settlement of 30 acres of land, which is registered as OA case number 664 of 1970. 2012-1971, Tahsildar Cuttack in OA case number 664 of 1970 settled 30 acres of land corresponding to CS Khata number so-and-so, CS number, which is a part of the intermediary interest of Radhakrishna Bharati and others in favor of Nityananda Bharati. 18/6/1976, record of right issued in favor of Nityananda Bharati in respect of the said 30 acres of land under Sthitivan status. 7/6/1980, out of the said 30 acres of land, Nityananda Bharati sold a part of it to the extent of 20 acres in favor of Messrs. Devata Construction, the petitioner, by registered sale deed. Yes, registered sale deed, basing on which mutation patta was issued in favor of Messrs. Devata Construction. 22/6/1983, Collector Cuttack made a reference under section 38B of the OA Act for cancellation of the settlement of acre 30 decimil of land made in favor of Nityananda Bharati, basing on which suo motu OA RC case number 78 of 1983 was registered in the court of the member Board of Revenue Orissa. In the said case, Nityananda Bharati was noticed and did not file any response. Messrs. Devata Construction was not made a party in that case. 5/8/1987. Final order passed by member Board of Revenue in suo motu OA RC case number 78 of 1983, cancelling the settlement of acre 30 decimil of land made in favor of Nityananda Bharati, which is impugned in this case. Nityananda Bharati, who suffered the said order, did not challenge it in any court of law and accepted it. 1988. The petitioner Messrs. Devata Construction, as a purchaser of a part of the land settled in favor of Nityananda Bharati, which was subsequently cancelled by the impugned order of the member Board of Revenue, filed TS number 640 of 1980 title suit in the court of the Civil Judge Senior Division Cuttack for declaration of his right title interest in respect of his purchased land of 20 acres and to declare the order passed in suo motu so-and-so as illegal. Nityananda Bharati was included as defendant number 5 in the said suit but remained ex parte. Nityananda Bharati was defendant number 5 and he said ex parte. 9/5/2000. Title suit number 640 of 1980 filed by Messrs. Devata Construction was dismissed on contest. Nityananda Bharati remained ex parte. The civil court recorded 3 important fact findings in the said judgment, namely, the order passed by the member Board of Revenue in suo motu case number so-and-so is legal, and that there is no record to presume that Nityananda Bharati was a tenant under the intermediary and was in fast possession of the land, which was settled in his favor by the Tahsildar in OA case number so-and-so, and that no rent roll is proved, so he cannot claim to be a tenant under the intermediary. Nityananda Bharati has no right title interest over the land transferred to Messrs. Devata Construction by means of registered sale deed, so no title passes to Messrs. Devata Construction in respect of acre 20 decimil of land by virtue of the said sale deed. The suit filed by Messrs. Devata Construction is not maintainable in view of the bar under section 39 of the Orissa Estate Abolition. All the findings are against the plaintiff, Messrs. Devata Construction. As a result of it, the suit was dismissed. 2000. Messrs. Devata Construction filed title appeal number 43 of 2000 in the court of District Judge Cuttack against the judgment passed in TS number so-and-so on 9/5/2000 within the period of limitation. 8/12/2000. During pendency of the said title appeal number 43 of 2000, Messrs. Devata Construction filed this writ petition by OJC number so-and-so in this honorable court, suppressing the fact about the judgment passed in and also pendency of title appeal number 43 of 2000 in the court of the District Judge Cuttack. Here I will pause for a moment. Yesterday, wrongly, I had made an argument before your lordship that before filing of the writ petition, the appeal filed by him before the district judge was dismissed. But later I found that the appeal was filed in 2000. Soon after that, the writ petition OJC was filed in this court, and during pendency of that appeal, this writ petition was filed. Am I clear, your lordship? During pendency of the appeal filed by him before the appellate court, and
that was dismissed in 2005.
Yes, that is annexed 14. So he maintained both the proceedings before the district judge and under the in parallel. There he filed the title appeal, which remained pending till 2005, and in 2000 he filed the writ petition before the for the self-same relief on the self-same pleading. Simultaneously, both the proceedings were. Now he is saying, I will place that. During 8/12/2000, during pendency of the said title appeal number so and so there. 2001, Messrs. Devata Construction filed another. This is very interesting. I have not pointed it out, and neither he has also pointed out. 2001, this petitioner again filed another suit, which your lordship will find from the counter affidavit filed by the Kotak Development Authority. In this case, he has the CDA has annexed the plain copy of this suit filed by this petitioner before the same civil judge senior division Kotak against CDA. In that case, the state was not made a party. Only the functionaries of Kotak Development Authority, they were included as defendants in that suit. Messrs. Devata Construction filed another TS number so and so against Kotak Development Authority involving his 20 acres of land, purchased land for permanent injunction, and at para 13 of the plain, it is stated that the findings rendered by the civil court in the judgment passed in TS number so and so are erroneous findings for which title appeal number 43 of 2000 has been filed by it. This suit is filed after filing of the writ petition. After filing of the writ petition, he filed another suit in 2001, and there is a positive averment therein in that para 18 that the findings rendered by the civil court in that suit are all erroneous finding. That is why he has preferred appeal, which is pending sub judice. Why I am saying all these things before your lordship? Because yesterday your lordship asked him that whether you accept the judgment of the civil court or you say that that is a illegal judgment. His submission will not help in finalizing the case or taking any view in this case, because there is an affidavit of this petitioner in the suit, in the plaint itself, para 18, stating that he has clearly stated that the findings in the civil court are erroneous. Then 15/3/2002, the intervention petition filed by Kotak Development Authority in this case, we are not concerned. Then 28/9/2005, title appeal number 43 of 2000 filed by so and so, dismissed by the district judge Kotak. So in 2005, 5 years after the filing of the writ petition, the title appeal was dismissed there. That is annexure 14. 2/9/2009, Messrs. Devata Construction filed rejoinder affidavit to the counter affidavit filed by the Kotak Development Authority. In para 14 of the said rejoinder affidavit, it has been suppressed that title appeal number 43 of 2000 was filed by Messrs. Devata Construction against the judgment passed in TS number, which was dismissed on so and so. 17/8/2005. Much after that, when this matter was reported to the court, that appeal was there and it was dismissed and it was suppressed. So he filed an amendment petition on 17/8/2015. That is 15 years after the filing of the writ petition. This amendment petition was filed by the petitioner. Mr. Devata filed one miscase number 217 of 25 in this writ petition, seeking amendment to introduce the fact of judgment passed in so and so and disposal of title appeal number by the district judge Kotak. The said amendment petition was allowed. Then 20th/4/27, consolidated writ petition filed by this one so on. So
in the first suit, whether the state of Odisha was party or not?
The state of Orissa was the main contesting party. We have filed written statement.
You are not state. You are Kotak Development.
No, I am state.
You are state. You are Kotak Development Authority. So you were a party.
The state government was party in the first suit.
Just a minute.
Your lordship may write, that is title suit number 640 of 1988, annexure 10.
And CDA?
CDA is not a party in that.
In that case.
Second suit CDA is a party.
Just a minute. And in second case?
Second suit number is title suit number 292 of 2001.
In which paragraph you have mentioned?
No, that is only against the CDA functionaries.
Page two, 2001.
Yes, my lord.
Page 2.
My counter, CDS counter.
Please, he has given a date chart.
In the title sheet, copy of the title sheet.
The copy of the plaint is annexed.
That's number.
TS 292 of 2001. So who was party?
That is, the defendants are only the CDA functionaries, not the state. No, state is, collector is not a party. The same petitioner has filed both the suits.
What was the fate,
Plaint.
fate of that?
That was dismissed. That was also dismissed.
So the two title suits were filed in relation to that plot. In first suit, state was party, CDA was not a party.
Yes, my lord.
In the second suit, CDA was party, state was not a party.
The first suit was tried, written, and
on party position.
On merit, it was disposed.
On party position, are we clear? That
Yes, your lordship is clear, party position.
All right. And in the third case, that is writ petition, the CDA was not party.
Subsequently, CDA intervened.
CDA was not party initially. Not party because you were party in, you were not party in TS 640 of 1988 also.
CDA was not a party.
CDA was not a party. Yes. Yes.
Here the catching point is, your lordship may kindly imagine, one suit was filed before filing of the writ petition and it was disposed of on merit. The second suit against the CDA was filed during pendency of the writ petition.
Yes.
And this second suit, filing up about the second suit was disclosed by the CDA in their counter affidavit and filed the plaint. So my response submission, much has been argued by my learned friend with regard to the Tenancy Act. The only submission, if your lordship will see from the pleadings, what he intend to establish, that is borne out in page 25 of the consolidated writ petition. What is the scope of the adjudication is, he is saying that the impugned order of the Tahsildar, Annexure 3, by virtue of which 30 acres of land has been settled in favor of his vendor, was in fact not passed under the OE Act, under section 6 and 7 of the OE Act. It is passed by virtue of a GO under lease principles. Therefore, the Board of Revenue could not have exercised jurisdiction under section 38B of the OE Act to annul that settlement. I am just placing 3-4 lines from the writ petition. On a bare perusal of the rent schedule and the reference made by the collector, the legal presumption would obviously be drawn that the settlement in favor of Nityanand Bharati was made under the lease principle, under GO number so and not under the provisions contemplated under section 6 and 7 of the OE Act. Therefore, the order of Annexure 9 passed by the member Board of Revenue.
What were the prayers made in the first suit? What was the relief?
The relief is his right title interest in respect of these 20 acres of land may be declared. And consequently, in consequence thereof, he has made a prayer to annul the, because unless that order is quashed or set aside, his prayer, his title cannot be decided. That Board of Revenue order has to be set aside. Thereafter only he can be declared as a lawful title holder in this book. I am just placing the Annexure 10, your lordship may see the judgment. This is a suit for declaration, but the issues which the learned civil court has framed, that is most important. Your lordship may see Annexure 10 of the writ petition. That is the judgment passed by the civil court.
Page?
My lord, Annexure 10 is
55.
Consolidated rate.
Yes, 55.
Consolidated rate petition.
Copy of the judgment dated 9/4/2000.
It is continuation page of consolidated writ petition.
Yes, consolidated writ petition lo kete achi? 55.
Lordship, get it on page 55 in my compilation that.
Oh, that compilation is there, that your lordship can find in page 50. I'm just placing what are the issues framed by the learned civil court in the suit. Whether the order of member board of revenue in so motto case number 70 of 83 is legal. Here also the same thing he is urging, that this order is illegal, therefore it is liable to be quashed. So the legality of the impugned order, which is the order which is impugned in the writ petition, was also tested by the civil court in this civil suit by framing a issue, and both parties adduced oral and documentary, oral evidence also, documentary evidence against this issue. The next issue is whether the plaintiff can challenge the said order. Yes. Number 3 issue is whether the plaintiff has got right title interest over the suit. So far as the first issue is concerned, that is most important because that is directly related to the relief sought for in this writ petition. Am I clear, your lordship? Whether the impugned order to this writ petition, that is Annexure 9, passed by the member board of revenue, which is sought to be quashed in
whether the third issue could have been decided independent of the issues number 1 and 2.
No.
That is for the reason that he was he claimed that the order is illegal.
Yes.
And 2, even otherwise, he has right title and interest.
Yes, ma'am.
Right. So because of the bar,
yes, ma'am,
under section 39, the trial court might not have gone into the question of legality of the order.
That I will place before your lordship.
Just a minute. Might not have gone, but yet the other issues were required to be decided. The trial court decided those issues.
All the issues.
All the issues, including that without interfering with or with the decision of the Board of Revenue, based on other evidence adduced, pleadings on record, the other issues were decided.
In this case is directly and substantially similar to the issue which was adjudicated by the civil court. That whether the impugned order passed by the member board of revenue is legal, and that issue was taken into consideration or adjudicated after evaluation of evidence adduced from both the sides. That is the finding is that the finding is the last portion I am reading, that the order of the member board of revenue is legal. And there are also consequential findings that the ex-intermediary, the person who was accepted as a tenant, he was never in possession of that land. Possession finding is also against his vendor. Everything is there. But the net effect of the finding under issue number 1 is that the order of the member board of revenue is legal. Then your lordship will see the next finding is under issue number 4 and 2, it is contained, this is section 39. And here the court said that section 39 is a bar to bar, and the final result is dismissed. So that whether his sale deed is legal and valid. There the court held, no.
Therefore, we are observing that the civil court could not have entertained the suit as against the relief for setting aside the order of the Board of Revenue, there being bar under section 39 of the Act.
My lord, in that event, he would have come forward with a petition under order 7 or order 13 to decide it as a preliminary issue. All the issues are conjointly heard and disposed of. Findings are rendered. All these findings cannot be said to be ineffective. But rather, I would say, your lordship is correct. Let us assume that since
This
the,
is what,
since the court,
just a minute.
people take it from another angle. What I beg to submit. What is his basic claim? Basic claim is that this is not an order under the OE Act. Therefore, 38B is not attractable by the Board of Trade. If this is not under the OE Act, according to you, which is also your case before the Learned Civil Court, but still the Learned Civil Court has given a finding that under the OE Act, Section 39, the suit is forbidden, this suit is not maintainable, then it is against your own case, and rightly you have preferred the appeal. In the appeal, you have stated that Section 39 cannot be a bar because the impugned order, the order passed by the Board of Revenue, which was passed under the OE Act, in a case where OE Act is not at all applicable, the lease was settled, the land was settled in my favor under the lease principle governing that geo. So if that is your case, and rightly you have filed the appeal against the finding of issue number 2, that this suit is forbidden or barred under Section 39 of the OE Act, then how you say that I have abandoned that appeal and filed this writ petition? During pendent, you could have filed appeal, and if in appeal, it could have been held that no, Section 39 is not a bar because the order which was sought to be set aside or sought to be declared as illegal is not an order under the OE Act. It is under the lease principle. The Board of Revenue has no authority. This finding could have been rendered by the appellate court because you have challenged it before the appellate court, but you did not take any chance. You remained by keeping the matter pending in the appellate court, and by suppressing the said fact, you have filed the writ petition before this honorable court challenging the same order, who you have suffered this judgment And all these findings are against you. And your lordship may see that this appeal continued till 2005. And in 2005, it was dismissed for default. What my learned friend has argued yesterday, that I abandoned that appeal. That is not a fact at all. Abandonment is only prescribed in Order 23 Rule 1 CPC. As your lordship knows, Order 23 Rule 1 is only remedy for a party to abandon the claim wholly or partly in any suit or appeal. In that event, it is incumbent upon the plaintiff or appellant to file a petition before the concerned court for abandonment of claim by way of withdrawal. Order 23 Rule 1. Rule 1, withdrawal of suit or abandonment of part of claim. Your lordship knows appeal is a continuation of the suit. Has your lordship got it? At any time after the institution of a suit, the plaintiff may, as against all or any of the defendant, abandon his suit or abandon a part of his claim, provided that where the plaintiff is a minor. So abandonment is
two is important.
Two, yes. An application for leave under the. So here it is not the case of the petitioner that he had applied for abandonment of the appeal of the case before the appellate forum, and the appellate forum allow him to abandon the case and pursue the remedy before. But here is a case where he deliberately maintained the parallel proceeding before the district judge and Honorable High Court.
Then what is the effect of?
The effect is, yes, that is, I am only submitting all these things, that this judgment rendered by this civil court, which is confirmed by the appellate court in 2005, will operate as res judicata for deciding this issue involved in this case. Because the same parties have litigated for the same issue, and this issue has already been decided by a competent court, and you challenge that before the appellate forum. You did not choose to continue that case, and the suit appeal was dismissed for non-appearance. That is still a misconduct of the petitioner, and therefore you cannot re-agitate the same prayer before this honorable court by saying that I have abandoned the claim before the civil court. You have filed the case, not that anybody else has filed the case. You have examined witnesses. Your lordship may see, witnesses are examined, documents are exhibited, and both parties are heard. And very peculiarly, at no stage, your lordship may kindly keep it in mind, the intermediary from whom he has purchased 20 acres of land, Nityananda Bharati, he is not coming forward. He is not contesting the case, suit. He is not appearing before the member board of revenue. He is not challenging the order which is impugned in this case, because your lordship may kindly imagine, the settlement is not for 20 acres of land for which the petitioner is interested. It is for 30 acres of land. He has purchased a part of it. So it is incumbent upon the allottee or the person in whose favor settlement has been made. He should have challenged the Board of Revenue order. He has neither contested the case before the Board of Revenue, nor he has challenged it, nor he maintained a stand or filed any written statement before the civil court, although he has been impleaded as defendant number 5, stating inter alia that no, this order is illegal. I am in possession of the land, and rightly the land has been settled in my favor by the Tahsildar in 1970. There is no action, your lordship, this is very important, there is no action, although there are series of litigations in which he has been impleaded as parties. He has not opened his mouth He has not stated anything, although the petitioner is claim is confined to a portion of the land settled in his favor, that is only 20 acres. Here there is a 30 acres of land involved. So far as the settlement, original settlement order is concerned, Annexure 3. He is only confined to 20 acres. By Annexure 7, he has purchased it from that. So all these, your lordship may see, the infrastructure of the case is the order of the member board of review, Annexure 9. If that goes, then all subsequent events will collapse. His sale deed, everything will collapse. Once your lordship will come to a conclusion that that order is illegal and liable to be quashed, then everything will be restored back. He will get the title, everything, sell it. But only my submission is that there is no scope available for the petitioner to agitate this point or these points before this writ court in a 226 jurisdiction after the same issue has been decided by the civil court at your instance. And challenging those issues, you have filed findings, you have filed appeal, and that appeal was dismissed. The judgment of the trial court has merged with the appellate court's order. Now, the only point he is raising, that since the finding is that the 39 is a bar, and therefore all other findings have become odious. There are absolutely no value of those findings. My respectful submission is that your specific stand is that the order of the Tahsildar is not under the OE Act. Therefore, the Board of Revenue could not have exercised jurisdiction under Section 38B of the OE Act. Good. If this is your stand, you have to maintain this stand, and you have also filed the suit on that pleading. If the court has rendered a wrong finding that no, it is under the OE Act, so Section 39 is a bar. So that is contrary to what you have pleaded in your plaint, and that is why rightly you have filed an appeal. So my respectful submission is that he cannot get rid of the findings rendered by the civil court in the civil suit judgment, that is Annexure 10. And so far as the acceptability of the judgment is concerned, the section the Annexure 10, he is making prevaricating statements before various courts at various times. I have pointed out before your lordship in the suit filed against the CDA, that is annexure to the counter affidavit filed by the CDA. My learned friend has filed that. He has categorically said that the judgment passed by the civil court, Annexure 10, is the findings rendered by the civil court in Annexure 10 are erroneous judgment, erroneous findings for which he has filed the appeal before the district. That is what. But in the writ petition and during the course of argument, your lordship has heard it. He is submitting that no, that judgment is correct. The suit is without jurisdiction. That is why I abandoned that claim and filed the writ petition. On one hand, at one stage, you are saying that the findings are erroneous, for which I filed appeal. Or at one stage, you are saying that no, findings, whatever finding that it is 39 is a bar. That means if 39 is bar, my respectful submission subject to your lordship's acceptance. If according to you, that the finding rendered by the civil court so far as issue number 2 is concerned is correct, then 39 is a bar, then it is an order under the OE Act. Then it is an order under the OE Act, then there is no jurisdictional error made by the Board of Revenue. He can exercise power under Section 38B of the OE Act. What is your case? Your case is that the order of the Tahsildar, although it is nomenclatured as Section 6 and 7 of the OE Act, but still it is not an order under Section 7 of the OE Act. It is an order under the lease principle governing that government order, GO. Well, it is a stand taken by you consistently from the date of filing of the suit till today. But if you insist on that stand, my respectful submission that if you insist on that stand, then the findings is according to you is erroneous finding and you have challenged it in appeal. Now, how can you again maintain a writ petition? That is the only submission before your lords. And so far as other matters that Orissa Tenancy Act.
No, we get a clear-cut answer on this? That if in a suit, 2 reliefs are sought, including one relief which is barred under law. All right.
Yes, ma'am.
On that ground, the suit cannot be said to be barred because other reliefs also
reliefs
have
are
been
there.
sought. So suit is barred to the extent the other relief has been sought.
Yes, madam.
All right.
Yes, madam.
And to that extent, the civil court has recorded a finding
Yes, madam.
that there being bar under section 39, the correctness of the order passed by the revenue cannot be gone into, may not be gone into. But so far other reliefs
Other
are
reliefs are
concerned,
concerned.
based on the pleadings
And the
and
materials of record.
evidence,
Yes.
pleadings and evidence, those issues could have been decided
Yes, ma'am.
in relation to other reliefs.
Other reliefs.
So one of the reliefs for declaration of his right title and possession,
Yes, yes.
that has been decided by the civil court, against which an appeal was filed.
And that
So
was
those findings, because those findings have, the appeal is too dismissed, therefore those findings will have its value.
it attained its
application.
finality. It attained its finality. So far as the right title interest is
So
concerned.
this is what we,
Yes,
we were trying to convey.
And here is a case your lordship will imagine in the civil court has decided all the issues against the plaintiffs. All the three issues have been decided against the plaintiff, for which he has preferred the appeal. Not that the other issues are in favor of the plaintiff. Only the suit was dismissed due to want of jurisdiction or due to bar under section 30. It's not like that. Because in some cases, I found that in some judgments, these civil courts are rendering judgment that all the issues, since there is a bar under particular provision of law, the suit is dismissed. And
If the suit is confined to that challenge,
only.
Then of course the suit will be barred.
Yes.
If the suit is confined to a challenge to an order passed under section 38B or under the provisions of 5 and 6, 39 is there, that will be bar. That will apply. But if there are other reliefs also sought, issues framed, issues decided, then
that will operate as res judicata for a subsequent suit.
Section 39 is confined to challenge against the
Board of
order of the
Revenue.
board.
And so far as right title interest is concerned, that is confirmed by the civil court and affirmed by the appellate court. And one thing I beg to submit before subject to your lordship's permission. This civil court judgment, incidentally, your lordship will find, although there is a finding section 13, but incidentally, the learned civil court has recorded a positive finding that it is legal. The order is legal. Because he said that order is illegal. That is the case of the plaintiff. Before this, the order is legal. There is a positive finding that your lordship can see. Only he says that section 39 is a bar, and this is one of the issues. Other issues are clear and unambiguous findings so far as the right title interest of the petitioner over the land in question is concerned. And more particularly, your lordship will find he stand on Annexure 7, that is his registered sale deed from Vidya Bharati or that Mr. Bharati. So that sale deed is declared to be illegal by the civil court under issue number 3 and 4. That he has not acquired any right title interest by virtue. Unless he gets rid of that finding, which is a finding of law and finding of fact, contested between the parties, then how can he say that I am the rightful owner of the property? His sale deed is no more survives.
Yes, anything else?
That's all. My learned friend will supplement. He will supplement.
I'm for the Kotak Development Authority. In fact, my lords, Kotak Development Authority is a creature under the Odisha Development Authority Act 1982, my lords. The whole objective is to see that the development planning and all these things have come up. In addition to that, to develop housing scheme and all this. In this case, there is the Kotak Development Authority has implemented two projects. One is called Shikharpur Housing Project, another is called Bidanasi Project. Bidanasi Project comprises of different sectors. Sector 1, starting from Sector 5, Sector 6, Sector 7, Sector 8, Sector 9, and Sector 10. For the purpose, the government in Revenue Department provided us the land on payment of the premium. For that purpose, either government managers alienates their own land in our favor, or they go for acquisition and thereafter they hand over the land to us, transfer the land to us for the purpose. Here in this case, my learned friend agreed and enclosed also this notification. I have also enclosed this notification in my annex counter. There was an acquisition notification in way back in the year, my lords. That is my counter. Well, so that is at my annexer at page 103 annexer, that is A by 1, A by 5 panels. That notification was of 1983. We have developed the project. People are in occupation. Substantial development has taken up. Since 1983, whilst this dispute has come up before this Honorable High Court in the year 2000. In the year 2000, well, kindly visualize one thing. Time is the essence. So far that litigation is concerned, my lord should appreciate it. You have claimed some title, but you know that there is a notification because it's a public notification. This notification was of 1983. You filed this writ petition in the year 2000 before. My lord. Yes, my lord. That all total properties. All total properties, plot number, khata number, everything, inclusive of this. All throughout it is government has treated this is their land, and accordingly there is a proceeding, my lords, that allotment has been made. Now it was of the 1983. Well, kindly visualize one thing. 83, a statutory authority has been given that property land has been transferred to the statutory authority. Well, this authority has carved out, allotted land, subdivided it, allotted land to different allottees. They have undertaken construction. They are residing there. Many infrastructure also facilities have been developed. Forms part of Sector 10. I understood from my officers, this area forms part of Sector 10, 20-30 acres of land. Of course, it's a very valuable land. At present, the value would be 4,400 crores or 500 crores total land. That is a different aspect altogether. But here in this case, you have come in a suit against me. But first suit was not against the CDA. In the year 1987, you tried to carve out a suit against the government only. Then, my lords, government, you lost this. There are some observations. My London friend already stated all these things. My lords appreciated this. Thing is that here in this case, declaration of right title interest. Let us forget about 38. What 38 operates a bar or not. You yourself have stated that this order is bad. You have gone there and you got that relief. Whatever relief you got, or whatever the observation you got, observation or relief, you are bound by that. You are stopped from raising anything contrary to that. Well, so this has attained finality after dismissal of the appeal. What my London friend submitted it, I don't want to repeat it. But fact remains, in the year 1987, you carved out a remedy in a suit. You have not implemented CDA as a party. In the year 2001, after filing of this suit, you filed another suit against the CDA. That matters I enclosed it. That is annexer. According to the year 19, one part is in the 1983, the second part in annexer C by 5, 84. 18th October 1984. This was 100%. These are all simultaneous. Of course, I have to take note of that simultaneous, because these are now growing areas, minors. Post locality, growing areas, hundreds and hundreds of the plots have been carved out. People have undertaken construction, residing there for more than 25-30 years, minors. It was in the year 1983-84. Well, I'm bound on minors, I'm bound on minors, I'm conscious of the position. Just to say minors about what is the present position, to bring it to the notice, kindly visualize one thing, 83, 84. But that exactly minors. Minors, exactly, I'm not going beyond that. I'm pointing it out that the acquisition was made in the year 1983 to 84 for the purpose of development of housing project.
That once the land was allotted to you,
Minors.
you ought to have been included as party.
Exactly, man. That exactly, minors. That exactly, minors. I want to put out what minors have brought it to.
Should have taken this be also that during the intervening period there have been developments and everything.
And that is there. That is what we have filed in so far the second suit filed against us. That is the title suit number 292 of 2001. That was dismissed.
Are not very material for this court.
Minors.
By considering someone's right.
Minors. That is correct. But my humble contention, you have resorted to a particular forum on your own prudence and wisdom. You have acted on that. There you have not implicated me as a party. Subsequently, you lost that suit and appeal. Maybe for any other reason. My learned friend has stated all these things. I don't want to repeat it again. Thing is that thereafter you set another suit for injection. You lost it. We are in possession of the property. Well, that is what I say. Now you are stopped arranging all this point after a long time. After much time in kindly visualize one thing, 83, the suit of this petition was filed. The first suit was filed in 1987. The second one against me was in the 2001, during pendency of this read. The read was of 2000. 87, 19, after 13 years or 14 years. Well, that is what my first limit of submission. Well, I am a beneficiary under the government. Government has given us the land as if it is the government land, and that land we utilized. So whatever ground government takes, this should be our ground, we have to step into their shoe. The second part, just beyond my scope, I'm my humble contention. Here in this case, so far that order passed under Section 38B by the member of the Board of Revenue is under challenge. Mainly on one ground, that it is settled under lease principle by the Tahsildar. So member of Board of Revenue seized with the power cannot enter. Well, if it is a lease principle, well, there are two contingencies. Suppose it is a settlement under 6, 7, and 8 of the OEA Act. Then the bar stands. If it is not a settlement under 6, 7, 8, and it is under lease principle, what my learned friend says, the member Board of Revenue has no jurisdiction. So question is, the Tahsildar once settled the land, it has attained finality. There is no provision of appeal because the circular my learned friend, the notification my learned friend refers to, that gives a right to the person if application is rejected, then they can prefer appeal. But they succeeded in application, so no such provision to prefer appeal. My humble contention, I am referring to this notification. Of course, it is beyond my scope of my argument, but any else to bring it to the notice of my lords, I am trying my best, my lords. Kind of a glance to that notification. The notification my learned friend refers to, which forms the foundation of the settlement. That notification my learned friend has referred to, well, that is an additional note on behalf of the petitioner. What this notification says, my lords. That is there my additional affidavit, additional note on behalf of petitioner that was filed on. Date has not been.
That is dated 2364.
64, 2364. Also, let us read this instruction very carefully, my lords. That gives all these ideas. What my learned friend says, whether it holds good or not.
Yeah.
May I read, my lords?
Yes, that we have seen.
That is, I may read matters, may be permitted. Before that, may I point out one thing? Suppose some person, intermediary, claims settlement of the land in his possession, that will be under section 6, then section 7, then they are to follow the procedure prescribed in section 8A. Here in this case, 8A provided 6 months time. That period was over. That period was subsequently extended to enable these his other intermediaries to file an application for settlement. Now, question is, this has happened those intermediaries who have not filed the petition in time. In this case, my learned friend's client admitted that this was filed way back in this 1970, 71, 72, 1970. My question is, this circular of 1964, this circular has come when many people, what they have done is, they filed petition within time. This was rejected, but taking advantages of the earlier circular, they again filed a petition for settlement. To avoid this mischief, to suppress this mischief, the government again formulated this rule, this scheme. But this scheme, kind of, I'm reading it. Meticulous reading of this thing will reveal so. I'm reading it that I am directed to say that under subsection 1 of section 8A of the Act, an ex-intermediary is required to make an application within a period of 6 months from the date of vesting of his estate, claiming in respect of which he is entitled to settlement under settlement of section 7 of the Orissa Estate Abolition Act. Similarly, under subsection, take 1 minute time, that is one part is missing in this. That is 64 notification.
Under section 6 and 7 of the Orissa
what part minus that?
Similarly,
That's if this portion has been scored.
under subsection 2 of the said section.
That clinches the issue. May I read it again, I am directed to say that under subsection 1 of section 8A of the OEA Act, an ex-intermediary is required to make an application within a period of 6 months from the date of vesting of his estate, claiming the lands in respect of which he is entitled to settlement under section 7 of the Orissa Estate Abolition Act. This is very important. Unless and until somebody is entitled to under section 7, he cannot file a petition.
Only 7 or 6 and 7?
And state claiming the land.
6 and 7.
6 and 7.
6 and 7.
Only claiming these, either 6 and 7 both, because these two provisions are settlement of land in respect of the intermediaries. No issue if it is under section 6 or section 7. Similarly, under subsection 2 of the said section, anybody rendering personal service to an intermediary and holding lands for the purpose of on favorable terms has to file his claim within 6 months from the date of vesting of the estate for settlement of his Jagir land under subsection 3 of section of the Act.
8
of the Act. Experience has shown that many people do not file claim petition under these provisions, even though they continue to occupy the land in question. The law provides that of such an application is at the time the land in question based in government and the person in possession has to be evicted. The very important thing is that those who after the notification period, the person who has occupation of the land not settled, they are to be evicted. As a strict application of these provisions would cause hardship, particularly to small intermediaries, like the petitioner's client, the petitioner itself. Given government in the past were pleased to order that even though under provisions of law, the land in question would be treated to have as having vested in the state government, would grant fresh lease of these lands to the concerned persons who would have been entitled to, but very important thing is that entitled to retain the land
Had they applied?
Had they applied for in time, the person concerned who could have applied within 6 months have not applied, then they are to apply under to get the land settled under lease principle. So basic thing is that somebody to get the benefit of lease or settlement, means he must be covered within the mischief of section 6 and 7. Unless he is covered there, he will not be protected under this circular. So any order passed under this principle, this notification, means it is only in connection with the right which is by lords buttressed in so far section 6 and 7 is concerned. Now then, my lords, land in question would be treated have been vested in the state government and would grant fresh lease to those land to such persons who would have been entitled to retain the land or realization of the area rent and salami equivalent to 3 years rent. This order of government was communicated in letter dated such and such, but it was noticed that some of the intermediaries who were applicant for settlement of land under the provisions of OA Act had earlier been rejected, took advantages of the concession to get back the land in respect of which their claims have been rejected. Because of this abuse, the aforesaid concession was subsequently withdrawn in due letter number such and such, pending determination of more suitable process under which it would be possible to accommodate the genuine case only. The withdrawal of the above concession was no doubt
caused hardship
to many intermediaries and jagirdars whose claims are genuine. After careful consideration of all these facts, government, that is now most important part begun. Government has been pleased to extend the said concession up to 36 to 1964 on the following terms, namely: 1. All ex-person who have not taken advantages of the statutory provision to retain the land in their possession under 6 and 7 and under subsection 3 of section 8 may put in application to the Tahsildar for lease of such land by 36/1964, after which date all application in respect to the particular village should be taken into consideration at a time, so that these would be of there will be no possibility of any fraud. So thing is that these persons, in order to be eligible to get a settlement on lease, means benefit, they are to be covered within the mischief of section 6 and 7. Unless and until he is a person to be covered under 6 and 7, cannot be brought within the scope of this lease principle. But then must be the ex.
Submission revolves around the fact that the reference under section 38B
valid. But my humble contention, the reading of all these would show clauses. There are other clauses also. Yes, my humble contention is threefold, not twofold, threefold. One, those are entitled to settlement under 6 and 7 would not be able to file it. They can file it, but that will be settled under lease principle. There is no such specific lease principle anywhere. But question is that government made an enabling provision to settle it. But first contingency is that they should be covered under section 6 and 7. They should be coming within the scope of 6 and 7. Here in this case,
that this settlement was not because of the provisions under the Land Reforms Act, but because of the government order. So what is wrong with this submission? It is only question is that in the present government order, only those persons could be settled lands on lease principles who could not avail the their entitlements under section 6 and 7. All right.
Got it settled. Not entitlement, got it settled under section 7.
No, not under section 7. It's a different policy of the government.
Yeah,
it's a policy of the government as contained in the government order that those who could not be settled, now this can be done on a different principle, not on the principle of.
But exactly, I'm coming to that. On a different principle, on lease principle, but fact remains they are within the scope of OA Act. What my humble contention is, they are within the scope of the OA Act.
provisions of the OA Act.
Minutes.
See, the government order qualifying those persons entitled for the scheme under the government order.
Minutes.
And the qualification is that you must be entitled for such settlement under section 59 of the Act.
Yes.
The qualification for the government order.
Yes, madam.
So he may be right in his submission that this settlement which was done in favor of the ex-intermediary was not in accordance with the provisions of the Act, rather in terms of this OA, this GO.
I'm coming to that. My humble contention, the GO, that has, but so far as the right of the person concerned, the intermediary, those who are protected under section 6 and 7, they may follow a different modalities. The modality is something different, matters. Direct settlement or settlement through lease principle, but they must be within the scope of 6 and 7. My humble contention, if they are coming within 6 and 7, be it a settlement under the lease principle or otherwise, means they are coming within the scope of OA Act because it is arising out of the OA proceeding only. Because
GO has been issued under any provision of the Act.
Minutes. No, this GO minus what minus the GO.
Separate scheme.
Minus
Different from the scheme under the Act.
Minus. This has been minus to my knowledge, that is not there. To my knowledge, it has been issued. No, minus that's what circular says, minus that is not there. But my humble contention, minus, may I repeat it again, minus for minus consideration. The thing is that minus here in this case, the GO enabled for a settlement under lease principle as a lease of the land.
So what do you want to submit?
My humble submission is that unless and until somebody becomes eligible under section 6 and 7, they cannot get a settlement. Here in this case, Tahsildar settled it. Tahsildar settled it. That order is not there. Tahsildar settled it. Against that, collector has written, made a requisition to get an adjudication under 38B. But question is, 38B, any land which is coming within the scope of OA Act, getting settled under the lease principle, maybe under lease principle, is coming within the scope of 38B. That is what my endeavor is, minors, to bring it to minors' notice. Minors, kind of a class to 38B.
Had this GO been not there, what would have happened?
The GO, had the GO not been there, minors, the land would be vested to the government.
Government?
Government
Must have vested to the government.
Already vested.
Mr. Before coming to GO, land must have vested to the government.
Yes, my lord.
By operation of
Yes, my lord.
of the.
Yes, my lord.
Therefore, for those vested lands, the government came out with this scheme.
Yes, my lord.
Containing this GO.
My lord.
That
That is what I am not disputing, my lords. Because this GO enables them to apply for a settlement subject to eligibility under 6 and 7. So it cannot be separated and segregated. My humble contention is that it cannot be separated and segregated. It would be a GO or also to carry out the objective of the Act itself. Objective of the Act itself. So my humble contention kind of a class than section 7.
We have understood your submission.
But thing is that section 7 must my motive. Another aspect, kind of take note of. I don't want to take much more time. Another aspect, reading of the collector's order, Annexure 9, Annexure 8, that will reveal two things, that is very important for minors' consideration. One is, this Tahsildar settled the land, then collector referred it to this the commissioner. Commissioner set it aside, minors. Question is, what is the character of the land? Collector in his letter has categorically stated the character of the land. Character of the land is Anavadi. Anavadi land, what is Anavadi land, minors? Anavadi land, that is what, minors?
The legal question is not that.
Minors.
The legal question is whether the collector could have referred.
Yes, madam. That exactly. My humble submission.
You have already submitted.
Yes, madam. My humble submission was for the purpose of repetition only, minors. My humble submission, the collector referred it under section 38. Section 38, the member of Board of Revenue have exercised it. In exercise the jurisdiction conferred under 38B and passed an order. Two aspects is very important. The petition, but here in this case, one thing I'll note it. Here in this case, the petitioner filed a petition under section 6 and 7, not under this notification, nor the Tahsildar taken note of this notification. That is what the collector has stated in Annexure 8. He filed a petition under section 6 and 7 after.
If state takes a stand that the reference was wrongly made, the reference was wrongly answered by the Court of Orissa. The petitioner filed a suit.
But that's what I will not do. That I understood, my learned friend.
That is your alternate submission.
That exact. I borrowed that submission, my lords. So far suit is concerned, once you prefer, you are bound by these observations. It is not that you have abandoned the suit. It is not that appeal has been dismissed. I borrowed that submission. Only thing I am to submit my so far merit is concerned. Here in this, it is an Anabadi land. Collector has categorically stated Anabadi land is not coming within the unused land. These are all unused land. The definition is there in judge's report. My learned friend also referred to that land is not coming within section 7. That is but my humble submission.
One line. The reference of the collector, which finds place at Annexure 8, consequent upon which the adjudication has been made by the command order impugned order. That reference, that is an administrative order of the collector. That is not challenged in the no prayer has been made to pass this.
Yes, anything else?
That I'll give a, because many things have been argued before your lordship now. But so far as the settlement is concerned, I will not repeat again. What they have argued, I will reply before your lordship. But fact remains, I was not the counsel when the suit was filed. And the suit, when the appeal was filed.
I was the counsel for the government.
You may be counsel.
No,
just I am saying.
Incidentally, my lord, I was
just
the
I am saying.
competitor when the suit was filed.
Just note the statement which has been made.
No.
Yes, Miller.
In a light
So
of
therefore,
Happens to be government counsel.
he was the government counsel at the time the suit was
I was
filed.
appearing in this.
What he is submitting. So here is the case, Miller. Miller, what I am submitting before your lordship. The fact remains, Miller. Your lordship asked a very pertinent question when two reliefs have been pled for in a suit. One relief is not maintainable before the civil court. And the other relief is maintainable. If the civil court has granted the relief about the declaration of title, it is binding, whether it is binding against that person, and it has a binding effect. This is your lordship's prima facie view by hearing the submission of Mr. Mahanti.
That is not our view. Our view, we don't know.
Yes, brother. But that is the prima facie, it is in your lordship's mind. I will give that reply to that query which has been made by your lordship. And I am supported by 3 Supreme Court judgments. If the suit has been filed claiming a particular relief, once the court has come to the conclusion that I have no jurisdiction, and on the basis of the order which has been passed, the second relief which is maintainable before the civil court has been decided, then in that case, my lord, the Supreme Court has observed that once the civil court has come to the conclusion that I have no jurisdiction and the suit is not maintainable, even if let that.
The question is that if there is one relief sought.
Yes, ma'am.
And the second relief is dependent on the first relief.
Yes.
Regarding, and the question arises as for the maintainability of the first relief.
Yes, ma'am.
Then the suit may be declared as barred, statutorily barred.
This is
But if the two reliefs are independent of each other.
Yes, ma'am.
Like one, you are challenging the order of the member board of review on only one part, and at the same time you are seeking declaration of title based on the evidence, pleadings and evidence. Then, so far the challenge to the order passed by the member board of revenue cannot be entertained because of section 39. But so far other reading, you proceeded with your reading the other reading. You did not want the first question to be decided.
Yes, ma'am. But here is the suit. But I cannot develop what has been prayed for at that time. But in the suit, it is a purely declaration of title. The suit was filed, title suit number 640 of 1988. The pure declaration of title over the suit land. The judgment which has been passed by the civil court, my lord, your lordship, kindly see for a moment. I am taking to your lordship.
Declaration of right title in interest.
Interest.
That is not prohibited under OER.
That is not
Under
prohibited.
39.
Or under 39, that is not prohibited. That is not prohibited. And your lordship also, it is not, I'll fairly submit before your lordship. If it is under the lease principle, then also the suit is not, but the suit is not barred. Because it is not under any of the provisions of the act. So therefore, suit is also maintainable. But what happened in this case, my lord, your lordship kindly see the judgment of the passed in the civil suit. But because, my lord, I am taking your lordships to that portion of the judgment because the entire my declaration of title in my favor, my lord, by refusal of title on my favor, solely based on because the member board of revenue has a hold that your settlement is illegal. So therefore, you are not entitled to title.
Those findings are bad. Those findings recorded by the civil court
Yes, ma'am.
are bad. You got him submit.
Yes, ma'am.
Can you make this submission?
Let us see.
Can you question the legality of the finding recorded by the civil court?
No. What I am submitting, my lord, because your lordship, my lord, your lordship kindly see the why I am taking to your lordship again to that issue number 3 and 5. Lord, issue number 3 and 5, my lord, at page 71.
Criticize the finding recorded
No,
by.
I will not. I cannot criticize, my lord. I cannot criticize. But what the fact remains, my lord, it is my submission subject to your lordship's acceptance, my lord. The fact remains, the civil court has said that this suit is not maintainable and I have no jurisdiction to go into the question of relief prayed for. I have no jurisdiction to go into the relief prayed for in the suit. That is the ultimate finding arrived at by the London Civil Court. In the absence of the same, this court has got no jurisdiction. I have read, my lord. So therefore, my lord, I am citing, I have given a compilation of these judgments, my lord. The lordship can see, I have relied upon 1922 Privy Council 241 and thereafter 1947 Calcutta 221 on this point. 47 Calcutta 221 and 1950 Privy Council, what has been decided up to till date, I have given all those judgments.
2005.
50 Privy Council, page 80. Let all the judgments, I am only reading one portion of the judgment of the Honorable Supreme Court on this point. When the court had come to the conclusion, when the court had no jurisdiction over the subject matter of the suit, it cannot decide any question on merit.
But that could have been raised in title appeal. Had you pursued that?
I will come to that. I will come to that. I will come to that. I will answer to your lordship. Then let me place those persons.
We are not sitting over the civil court's
No,
judgment.
I am not saying so. I am not saying so. It can simply decide on the question of jurisdiction and coming to the conclusion that it had no jurisdiction over the matter, had to return the plaintiff. if he has decided simultaneously that you have no title over the property, then that will not operate as res judicata so far as the other proceeding.
Right.
Mila?
But the civil court would decide your right title and.
Yes, my lord. If even I have gone, my lord. If the suit is not maintainable, and your lordship can see the other decisions also, my lord. Here is a suit, non-compliance of section 80. I have relied upon that 1947 Calcutta, my lord. Non-compliance of section 80 CPC. I have filed the suit. The court simultaneously decided that suit is not maintainable in view of non-compliance of section 80 and also went to the relief prayed for in the suit. By relying upon the 1922 Privy Council, the Calcutta High Court hold that no, once you have decided that the suit is not maintainable and you have no jurisdiction, whatever observation, whatever finding you have rendered, that is simple obiter. That cannot be looked into. And that is also followed in so many Supreme Court judgments. And this is the judgment I am citing, that is 1965 Supreme Court 338. In all these points. So far as the appeal, I have gone in appeal. My learned friend has said that you had gone in appeal and you challenged the judgment of the judgment passed by the trial court. So therefore, my appeal was, it fact remains, my appeal was dismissed for default. So therefore, the judgment which was passed gets confirmed by the appellate court. The net result of the legal effect is that the judgment passed by the trial court get merged with the appellate order, and that has been confirmed. So therefore, the fact remains that the civil court had no jurisdiction. And to approach this honorable court, I do admit that the appeal was preferred, appeal was pending. At this juncture, in 2000, this writ petition was filed, disclosing of the fact that the civil court has come to the conclusion that civil court had no jurisdiction. This much of fact we have disclosed before this honorable court. So far as the pendency of the appeal is concerned, that was not disclosed. And subsequently, the appeal was dismissed. I brought it by way of amendment and incorporated in the before this honorable court. Once the amendment is allowed by this honorable court, then it will go to the stage of original proceeding, as if it has been taken when the original proceeding was filed. That is the law what I have understood. So therefore, the amendment which was carried out and this honorable court allowed the amendment, it is a part of the original pleading. And I am placing before your lordship that part of the amendment which was carried out, that is under. Yes. Yes. Yes.
But when we are hearing the writ today,
yes,
we also see the conduct of a party.
Conduct of the party. Yes, yes, my lord. It is a court of equity. I am well conscious, my lord. Your lordship is exercising the jurisdiction on Article 226. Your lordship has to see the conduct of the party. This court, yes, I am well conscious, my lord. So therefore I am submitting, my lord. So far as this proceeding taken up before the trial court, my lord, and before the civil court, my lord. When the civil court came to this conclusion, and the appeal was preferred at this juncture, I preferred the writ petition, my lord. So therefore, it cannot be said that my writ petition is not maintainable before this honorable court. My lord, my writ petition was maintainable. My conduct is that I was choosing a wrong forum. I had chosen a wrong forum.
You suppress the fact. That was very detailed.
No. With no, that is not bad. But appeal filed, that was not before this honorable court. That was not within my knowledge when the appeal was filed. Yes, my lord, that is a fact. I cannot develop it. I cannot develop it. That is a fact. whether that suppressor, whether that and subsequently, so therefore I am submitting before your lordship by way of amendment, I have disclosed before this honorable court.
Take a plea. You can take a plea that non-disclosure of that fact
Yes,
may not amount to suppression of
material fact.
in an adversarial litigation.
Yes,
Where the other side can take this plea.
take this
He
plea.
had filed.
Yes, he had filed.
You have disclosed after CDA filed, the CDA was impleaded and filed counter.
After 15 years.
No,
After
not
15
after
years of
counter.
filing of
Not
the-
after counter.
In 2015, after the CDA filed the
Lord,
counter affidavit.
The appeal was filed. What my honorable Chief Justice has asked to me, that you can take a plea that this disclosure, what I am trying to impress your lordship, Lord, this non-disclosure, what would be the original result, Lord? This non-disclosure is not such a fatal to take stretch to such an extent that my conduct is bad. And I have not disclosed before this honorable court, Lord. Since your lordship is a court of equity and your lordship is taking into consideration that a person, he is the intermediary. I am not repeating, my lord, again the submissions which I have made before your lordship. He is an intermediary and he is entitled for settlement, and settlement was done by following the lease principle, and I have submitted before your lordship, if it is a settlement under 6 and 7, only rent will be fixed. Yes, my lord, I have made, my lord. I have made. So far as the maintainability of the writ petition is concerned, my lord, this is my submission, that since this honorable court had the jurisdiction, and another judgment, though I have not cited earlier, my lord, I am citing before your lordship, that if your lordship come to a conclusion that the order which has been impugned before your lordship is palpably that authority had no jurisdiction, even if I have not disclosed before your lordship the pendency of the appeal, my lord, then also, if an order is totally without jurisdiction, it is a nullity, and it can be challenged at any stage before any proceeding, even in a collateral proceeding also. Lord, I am citing that decision before your lordship. First, the Odisha High Court decision, then I will go to the judgment of the Honorable Supreme Court. Your lordship can see, this is the 1943 CLT, page 681. Volume 43 CLT. Your lordship can see for a minute.
But your prayer is not to quash the civil court's judgment.
That need not be. That is not required, my lord. I will satisfy your lordship. I am before this honorable court to quash the order of the member board of revenue who had no jurisdiction. For that purpose, I am citing this. Yes.
That unless you get over
Yes.
the finding recorded by the trial court, you may not have any case.
Yes. Yes, my lord. But that is volume 43 CLT, page 681. Volume 43 CLT, my lord. Patak law times, my lord. Patak law times. Yes, my lord. My lord, page 681, my lord. I am only, but the honorable court, the division bench has quoted a passage from the judgment of the Anismani case, my lord. And I am just placing that portion, my lord. I will not burden your lordship with the judgments. That the
Talk about this legal position.
yes, my lord. The word jurisdiction.
Beyond jurisdiction, only beyond jurisdiction, completely beyond jurisdiction.
That can be challenged in any proceeding at any stage if it is used against that person, my lord. But it is volume 43 CLT, another judgment. They did. My lord, 2004, volume 8, SCC 706. In this In this point, I am citing these two decisions, my lord. And so far as what would be the legal effect of that civil court judgment, I have cited all those decisions. Then, my lord, I am going to the labeling of the application which has been made under 6 and 7. What my lord and friend is tried to submit before your lordship that you have made the application under 6 and 7. Tahsildar has passed the order of settlement. So purportedly this is an order which is coming within the jurisdiction of the act, within the purview of the act. Lord, I am citing two judgments I have relied upon and I have also given in my compilation. Labeling of application under 6 and 7. If it is a time has already passed, statutory period provided under the act has been elapsed, thereafter the application has been made. The authority, it is incumbent of the authority, and once the salami has been fixed, even if the labeling of the application under 6 and 7, that cannot be treated an application under 6 and 7 of the OE Act. But I am relying on ILR 1970 Kotak 941 and 1973 2 CWR 1122. I have given those compilation in my paper book.
Our problem is
Yes, ma'am.
that you are not clear on your stand. For the reason that on the one hand, you are saying that no application was filed under 6 and 7. Therefore, that order was beyond jurisdiction, and therefore section 39 will not apply.
Yes, ma'am.
And therefore suit was maintained.
But I am saying through suit as maintainable, but what I am impressing upon your lordship,
And
Lord.
again, you are saying that it was not maintained.
No, I am not saying suit was not maintainable. I have chosen a forum before this honorable court who had the jurisdiction over I have chosen the forum. I have left though I have filed the appeal, but by leaving the appeal, I have chosen this forum.
Was not useful against that order.
Yes, ma'am.
Then you could have simply pursued your case of right title and interest.
The right title interest, I am not disputing that. But I have did that. I had did that. But the trial court has said, the civil court has said that I have no jurisdiction. So far as the maintainability of this proceeding is concerned, my lord, I am again respectfully submitting before your lordship with all humbleness.
Till any void order or judgment or decree is set aside or varied or quashed by competent court,
Yes, ma'am.
that is held to be valid.
Civil court is not the competent. My lord, civil court has said.
What I say?
My lord, what the civil court had.
Void order.
Yes, my lord.
Void decree.
Yes, ma'am.
In your opinion, maybe.
Yes, ma'am.
But that has to be till it is set aside.
Till it is set
by
aside.
competent court of.
Yes, my lord. My lord, according to.
It is held to be valid.
Yes, ma'am. According to my submission, my lord, this is the competent court of law to examine the correctness of the order passed by the member board of revenue, my lord. I am not in the civil court decree, my lord. I am on the civil court decree. I will submit before your lordship that with all humbleness, my lord, I am submitting before your lordship that civil court has passed the decree. I cannot develop it or I cannot deny it. It is a admitted position. Civil court had passed the decree. What the civil court has done? Civil court has said that I have no jurisdiction. So far as this proceeding is concerned, my lord, whatever finding has been rendered by the civil court, that cannot be operated as res judicata so far as this proceeding is concerned to re-agitate that issue before this honorable court by the petitioner. That is my submission. And lordship can see, then only one decision I am citing, but I have also given that in, that is volume 63 CLT, page 5 to 6. That is a division bench judgment of this honorable court. In that case, the this division bench of this honorable court has hold that once the salami has been fixed in the order of settlement, that judgment I have not cited before, Your Lordship. That is volume 63 CLT 5 to 6. I have shown the statutory provision to Your Lordship. By interpreting the statutory provision, this honorable court in a division bench of this honorable court in a judgment, that is 63 CLT 5 to 6, have hold paragraph 6. I am only placing the paragraph 6.
You have supplied that. You have supplied that in this paper.
Yes, madam. I have given in my compilation.
Yes, sir.
I have given. Volume 63 CLT. Coming to the order of the member board of revenue, dated so and so 1982. It appears that the member board of revenue had exercised his jurisdiction under section 38B of the Orissa State Abolition Act. But as you have stated earlier, the order of the Tahsildar was under the lease principle and not under the provisions of the OE Act. Therefore, section 38B of the Orissa State Abolition Act cannot have an application in the settlement in question, was not under the provisions of the said act. In this view of the matter, we are of the opinion that the Board of Revenue had no jurisdiction to exercise its power under section 38B. Why? Because the order of settlement was on the basis salami was fixed in there. The court has taken into consideration section 6 and 7, only the rent, and under the lease principle, rent, in addition to that, 3 years rent as a salami. Once the salami is realized, it cannot be held as an order under this act. So therefore, the order is without jurisdiction. Once the order is without jurisdiction, I have already submitted before Your Lordship that I have challenged it. Then, my Lord, so far as the acquisition is concerned, my Lord friend has raised a question that this property was acquired by way of a notification, and on the basis of the acquisition, acquisition notification was made in 1983. We have exercised the power, and this person has not challenged it for a long period. Your Lordship, I am placing that acquisition notification. This property was not a part of that acquisition. I'll show that, Your Lordship, it is in my compilation at page 123, the notification, what my learned friend has annexed. That the plot number 34 was the part of the acquisition. Plot number 34 at page 124. Plot number 34, 78.90. My plot is, this notification was made in 1984. The first notification was made, that is annexure A by 5, that is 25 July 1983, the same position. Section 4 notification, Section 6 notification. Section 4 notification, 34, 78 by 90. My plot is, Your Lordship, you can see. My plot is, my settlement was in the year 1971, and the separate plot was allotted to me. Your Lordship, can see. My plot was the khata number 326 by 1, plot number 34 by 1845, 30 acres. It is a by plot. It was not included in that notification. And it was not a subject matter of acquisition proceeding in 1983. That is not there. After this, very strangely, after this, in 1996, I have also given in my rejoinder, in 1986, another notification was made by the Urban Land Ceiling Act for acquisition of this land, where I have shown as the owner in 1986. That is at page annexure. That is annexure 14 of my compilation. at page 186 of the rejoinder affidavit. I have marked it as Annexure 14. At page 186, Lord. It was a part of under the Urban Land Ceiling Act. The notification was made showing me as the owner in 1986. Thereafter, a proceeding was taken off, and this land was free from ceiling. So therefore, the submissions which has been made by before your lordship, Lord, this is the part of the acquisition proceeding, and we have acquired the land. Government has acquired the land, and the government delivered to us, and we are in possession. So far as, Lord, another aspect, both my lord and friends have submitted before your lordship that we have filed another suit, that is suit number. That is suit number 292 of 2001. After filing of the writ petition against the CDA, we had filed that civil suit, and that suit was only for injunction against the CDA because the CDA was interfering in my possession. That is the simple suit for injunction. And what happened, Lord, while this civil suit was pending, the CDA intervened in this writ petition. Intervened in this writ petition, and after their intervention was allowed, we filed an application seeking injunction in this writ petition. I have annexed that. This court granted injunction. After hearing that the civil suit civil suit is pending, and they have gone to the civil court, they have filed the appeal. Everything was placed before this honorable court. This honorable granted the order of status quo. So therefore, we did not pursue that injunction suit because we have got the relief before this honorable court. So far as that suit is concerned, it is a simple suit for injunction against the CDA because the CDA, having no authority, was interfering in my position. When this honorable court has, that order is, filed by the CDA, that is on 29/4/2002. Writ petition admitted for hearing. Status quo over the property was directed to be maintained. 29/4/2002. That is an order by the Honorable Justice D. Then was Honorable Justice R.K. Patra and Honorable Justice P.K. Mahanti. All these questions were raised by filing the intervention petition, and also I have filed the injunction application. They have filed the reply to that injunction application. I have annexed those documents in my compilation also. But that is at page. At page 83. Intervention petition. Thereafter, my injunction petition. I have annexed it. But my miscase number is 2879 of 2002. So therefore, this is the reason for which the second suit was not pressed. Because we got the injunction order from this honorable court. So therefore, thereafter, we did not press that suit. And so far as the appeal is concerned, my lord, I am leaving it to your lordship's lord. Appeal was filed and appeal was pending. At that time, this writ petition was preferred, and pendency of the appeal cannot be operated as a bar according to my submission, my lord, subject to your lordship's acceptance. When the order has been passed by a quasi-judicial authority, And in these circumstances, that order has been challenged before this Honorable Court, my lord. And that order is palpably without jurisdiction. So therefore, concluding my submission, my lord, I will summarize my points. Even if we have gone to the suit and there is an order by the civil court, bereft of that order, my lord, even the civil court has passed that order. So far as this writ petition and entertainability of this writ petition cannot be, and writ petition cannot be dismissed on that ground, my lord. When the civil court has come to a conclusion that I have no jurisdiction over the point and the merit, so far as whatever finding he has arrived at on the merit, that will not operate as a res judicata so far as this writ petition is concerned. When the order of the member board of revenue, my second submission before your lordship, when the order of the member board of revenue, I have placed all those documents, my lord, which has not been disputed. And he is admittedly an intermediary, and he did not file the application under 6 and 7, and which would be evident from the reference order itself, my lord. He did not file an application. Thereafter, in 1970, he filed the application, and it was disposed of by fixing the rent in addition to salami. So therefore, it cannot be treated as an odd settlement under any of the provisions of the State Abolition Act. It is under the lease principle. So therefore, member board of revenue had no jurisdiction. Once an order suffers from jurisdiction and it is used against me in any of the proceedings, that should be declared as nullity. And so far as the acquisition is concerned, I have shown to your lordship this plot was not a part of the acquisition proceeding. That is my submission.
Date chart may kindly give.
That I have given the original note and an additional note also for your
That date
lordship.
chart today I have given. And the date showing that when the amendment was filed by him, incorporating the fact of after 15 years of filing.
Yes. I have given that. Lord, we are highly obliged your lordship's patience hearing this matter. That is a old matter. It has come to an end.
You are concerned of the fact that this matter was pending.
Yes, my lord.
One of the oldest case perhaps.
We are now, what would be the decision, that is immaterial. But we are now getting a pleasure that a 24 years litigation is come to an end.
When the suit was there. And
Yes. Obliged. Obliged.
We are fortunate that you defended the suit and
yes, my lord.
defended here.
I was there for the state in the trial court also.
My lord, my friend was from the beginning in the trial court.
Item 24.
Please, your lordships.
The lordships can just have a glance at the rejoinder that I have filed, because if your lordships know that 260 acres land was required for setting up of the industry, which was not provided for. And their argument on that day that I was satisfied when I accepted 120 acres. And they wanted to show a document which said that I have accepted that 120 acres. So, my lord, I've just filed the rejoinder after I got this, my lord, the copy of the counter affidavit. If your lordships can have just glance at the rejoinder affidavit. That was, my lords, filed on
Dated
12/4. 12/4/24. I've given in the first 2 pages the dates, the relevant dates, so that just to make it concise, so that I can. The lordships got it. Yes.
226. 226.
Lordships, in Orissa, there's a corporation called EPCOL, which is the Industrial Promotion and Investment Corporation Limited. So when an industry is to be set up, first the proposal is given to the government, which is examined by EPCOL. It will see its feasibility, the requirement, and the approval, administrative approval is given first by EPCOL, then it goes to the IDCO, to the state government. State government asks the IDCO to provide the land. In this case, my lord, in 7/8/2003, EPCOL assessed the requirement of land was 260 acres. It was not my choice, neither it was IDCO's choice. So EPCOL assessed that for setting up of this industry, 260 acres are required, land was required. Then, my lord, that MOU was signed. Then, when in 2004, initially, when that particular land, which was earmarked in the MOU, was not available because of certain other administrative reasons, an alternative land was found out. And we said that you can give us the land which is available there. So at the first stage, my lord, on 24/6/2004, IDCO allotted the land of 120.12 acres. And then they relied upon a letter where they said that I was satisfied with that this was my choice. And I said, or the petitioner company stated that this will be good enough. So I'll take your honor first to that later so that I'll come back to the subsequent letters. Lord, that is part of the counter affidavit which was filed. See, we are happy. Excellent. Right. Hmm? No. No, that document, that particular document. Of page 11. Date credit. Accept. 20, page 47. It's page 47 of the brief, if your lordships can just have a glance. Page 47, Lord, that is part of the counter which was filed by IDCO.
112.
This was dated 28/6/2004. My lord,
This is your letter.
this is my letter. My letter. This is what they stated, that this is to the satisfaction that this is the entire which was required. So that was dated 28/6/2004, where I have acknowledged the receipt of the 120.12 acres. Thereafter, my lord, had it been the case so, the subsequent allotments would not have been there. The second allotment came, my lord, that was on my lord, 27/11/2004. They said that IDCO directed the petitioner to deposit amount towards further area of government land measuring to acre 22. So that later was the first portion or the first allotment of the land. Then, my lord, we made the application to the Pollution Control Department to get the consent to establish. And then the consent to operate will come and all that. So the Pollution Control Board wrote to us stating that on 17/9/2005, where it said that you have to leave out certain area. I have annexed that document to my rejoinder. If your lordships can just have a glance at Lord, internal page 22 of the rejoinder, that is annexure 10. I'm sorry, annexure 11, page 23. That would be, I think, running page 183 if my numbering is matching your lordships brief.
State pollution control.
State pollution control.
17/9/2005.
17/9/2005. That is page 183, my lord. Is it the same number?
That is 249. It is 20. No.
Your lordships got. So lordships would come to the second page where the special conditions have been mentioned. The first page is the general condition. The second page is the special conditions. The first condition. Major air polluting units like raw material handling, DRI clean and other units shall be located at least at a distance of 50 meters from the highway, 500 meters from the highway and major human habitation. And just prior to that, my lords, if your lordships would come to page 182. More regions. This was my letter, which was in response to their letter. I'll come to that later, my lord, subsequently. If your lordships would see, with reference to this letter, which has been mentioned, which is of 13/4/2005. We are sending here with detailed informations over documents required by your good office for allotment of 117.88 acres of land in favor of our proposed integrated steel project in village Thaibarana under Bonai Tehsil in the district of Sundargarh. And the letter which was given by them, which is 13/4/2005. No, my lord, absolutely no issue. If your lordships can keep it to next tomorrow, there is some other matter because of my personal inconvenience. I request.
Not tomorrow. Next week.
Lordships can keep it to Monday, subject to it. Monday.
Please continue.
All right.
Please continue if you can.
No, I can, my lord. That is no, the only problem is because of the later filing, my lord, these dates and all these documents.
Hello, I am appearing for copy number 1. Idco, my lord, with Mr. Abhijit Patnaik. Let it be next week, my lord.
Let him complete, Mr. Patnaik.
Yeah.
Yes, ma'am.
If your lordships may come to page 153, annexure E/2. The part of the state government's reply.
E/2.
Yes, my lord. That is at serial page number 153. Lordship. This was a letter by IDCO to the Joint Secretary to the Government, Steel and Mines Department, which has been filed by the OP number 2, which is the state government, the Government of Steel and Mines, their counter. If your lordships may come to second para. In this connection, EPCOL had assessed the requirement of land and recommended for acquisition alienation of land to the extent of 260 acres in favor of the company wide their letter number so and so. Government and Industries Department wide their letter number so and so communicated the orders of government to allow change of location of the project from Kumarmunda to Thaibarna under Bulai Tahsil. Accordingly, IDCO allotted government land measuring 142.12 acre in the village in favor of the project. Now, Messrs. Deo Mines and Minerals Limited has requested this office to acquire alienate balance land to the extent of 117.88 acres in different villages under Bonai Tehsil for the project, the details of which are furnished below. So, my lord, the requirement has never changed. Neither I have changed the requirement. It has been 260 acres as has been proposed by EPCOL. In different phases, they allotted me in the first two phases, and this third phase was never carried out. Though they have also sought for permission, if your lordships would see in the same letter, IDCO has filed alienation proposal of balance government land measuring acre 51.71 village Thaibarna before the learned Tahsildar for processing of lease proposal. As regards acquisition of private land, the same has been processed to the extent of 64.45 acres. It is therefore requested that administrative approval of government may kindly be accorded for acquisition of private land to the extent of 64.45 acres in favor of the company for processing and issuance of 4-1 notification. So they admit, they accept, and then the next page is the administrative approval, which, my lord, on 29/4, which is page 154, that was by the Department of Steel and Mines. Yes, ma'am. The next page of the letter I was reading, my lord, the subsequent page, which is annexure. My lords, a joint secretary government to the general manager P&A. Administrative approval for acquisition of private land for the purpose of steel project proposed by Messrs. Deo Mines Minerals Private Limited. If your lordships would see, this was dated 29/4/2006. And prior to that, in 2005, the first notice of termination of the MOU was issued to me and the land allotment, which was subsequently, as I pointed out on the last occasion, after I gave the representation to them that these are the issues. So they accepted it and acted upon it. So this 260 acres requirement has been consistently there from the beginning till end. But no steps were taken to provide me with the additional 117 acres. And what was provided of the 142 acres, almost more than 60 acres could not be used or could not have been used because of the passing of the national highway near that particular allotted land. So that was the reason I had given to them in specifically in writing that unless you allot this area, then only it will be possible for me to plan out and start the project work and start the construction so far as the industry is concerned. Otherwise, it will not be, because with the rest 50 acres or 60 acres that is left with out of the 142 acres, I could not have set up the plant. And if I would have started from one end, I didn't know that whether the land which will be allotted to me later on will be adjacent to it or on the other side. So that was the reason why the project could not be started. And the impugned order, if your lordship should see the impugned order, I'll come back to that, my lord, which is start from page 15 of my writ petition, where the disposal order was passed. Yes, and page it starts the communicate, the forwarding later or the attached later is 15, 16, this starts the order. If your lordship should come to para 3. Yes, my lord. How the facts have been misrepresented in the order itself. On the request of the petitioner company in their later dated so-and-so, IDCO allotted an area measuring 120.12 acres of government land in village so-and-so in the district of Sundargarh in favor of the petitioner for establishment of integrated steel and ferroalloys plant in their later dated 24/6/2004. The petitioner company accepted all the terms and conditions of the allotment in its later dated so-and-so. A lease deed was executed on so-and-so date and possession was handed over to the company. Subsequently, a patch of government land measuring 22 acres was also allotted in favor of the petitioner company for establishment of their integrated steel plant. And the possession was handed over on 18/1/2005. The OP IDCO in their later number so-and-so and subsequent later dated so-and-so requested the company to communicate the present progress of the civil works for further action. Finally, IDCO issued notice on 7/12/2005 to submit the progress of the plant within 15 days, failing which allotment shall be deemed to have been cancelled for breach of terms and conditions of the allotment. That was 7/12/2005. And if your lordships, I had just pointed out, the administrative approval was given in 2006. And there later itself is in 2005 when they sought for the allotment on 16th March 2006, IDCO's later. Then, my lords, the OP IDCO in its later dated number so-and-so dated 18/1/2006 afforded one more chance to the petitioner to expedite the construction of the plant, etc., without further delay, and report the progress of the work periodically to the concerned quarters. The petitioner neither submitted the progress of the plant nor implemented the project. The collector Sundargarh in his later dated 21/5/2008 intimated that the land allotted to Messrs. Deo Mines Private Limited has not been utilized and the company has not started commercial production even after 2 years from the date of taking over possession, with a further request to cancel the allotment of land and evict the company. Their own letters, interdepartmental communications, government communications, everything is there on record before your lordships, which shows that the land was never allotted to me, which was required for the plant. And no 4-1 notification, even though the government gave the administrative approval, no formal notification was made for acquisition.
And which is that body you said?
EPCOL. IPICOL, Industrial Promotion. That is, my lord, part of the MOU where the MOU is there.
Oh.
Yes. Industrial Promotion and Investment Corporation Limited of Orissa Limited. It's a state government organization, public sector. They give the approvals and also in certain cases, they also finance.
What evaluates?
Evaluates the project, the feasibility, the requirement.
No, my lord. That 260 acres was never in dispute. We have never disputed their assessment. We have not asked for more than 260 acres ever even. Neither the 142 which has been no, that is on record, my lord, that they have given the approval, which is part of the. Yes.
Whether without 260 acres, complete 260 acres, you could have started establishing any work over the land for the
Yes.
purpose of establishing the road. That is the main question.
That is the main question. Now, once 142 acres was given to me, and out of that 70 acres becomes unusable or for the purpose of setting up of the plant, whether within the rest 60 or 60 odd acres, which I have also mentioned in my representation, which I had given to them, whether that could have been, Lord, if your lordship should see,
Where is the evaluation done by EP? Where is the assessment?
no, that is not on record, but that is part of the, in the MOU, it has been mentioned and in there. Yes, my lord.
So want to understand the way, why the EP and
A particular figure, let's say. Lord, if your lordship wishes, we can also add them as parties. There is absolutely, I have no, Lord, grievance on that. I can.
Because actually, we tend to resolve the entire dispute.
Yes.
EP will have to play a very important role.
As your lordship wishes.
Lord,
What do you suggest?
My lord.
Lord, what I am submitting, Lord, it may not be necessary, Lord. And what we are with all. I am
For
the private parties.
For the comment.
He is for the IDCOM, Lord. My lord, your lordship should understand the ambit and scope of the present litigation. My submission is that ambit and scope of this present litigation doesn't admit any scope for argument about the adequacy of the land or not land. Because the beginning point of this writ application is the judgment made by this honorable court. And whether the directions of that judgment has been followed, and in terms of the judgment, whether he has given an undertaking, and it failed to consider the same. This is all this is about. If so, the beginning point will be the judgment, not any and all action post to the judgment.
All right, so we are not required to
Add.
to increase the call.
Lord, one more thing, my lord. My lord, in the rejoinder, when they have stated that when they filed an application, my lord may read that rejoinder for a once, my lord.
No, we will have to hear it first.
Right.
We cannot argue. Yes.
So his prayer, what I beg to suggest, his prayer in the earlier writ application was never about the adequacy or non-adequacy of land, or not has he ever sought for a direction to allotment of land.
My lord, may just I may be, pardon my lord.
Please let him conclude, otherwise the hearing.
Yes, my lord. But actually, your lordship should seize the direction of the judgment, my lord. Last judgment passed by this honorable court.
We will see.
My learned friend is right, my senior friend, Mr. Mahanti, that there is a limited scope because the honorable apex court has stayed the judgment.
We will see.
Stayed the judgment.
We will see.
And has asked
Mr.
for the
Patra,
disposal.
please let him conclude his submission.
All right,
Mr. Patnaik, please let him conclude. Sorry. Yes.
Lordships, I was taking your lordships through page 17, the order which has been passed, the impugned order. Lots of, got that page.
Yes, we will get, please.
Para 4 midway, my lords, the OP IDCO in its later number so and so, later number 999, page 17 of the brief.
Yes.
OP IDCO in its later number 999 dated 18/1/2006 afforded one more chance to the petitioner to expedite the construction of the plant, etc., without further delay and report progress of work periodically to the concerned quarters. The petitioner neither submitted the progress of the plant nor implemented the project. Excuse. The collector Sundargarh, by his later dated so and so of 2008, 21/5/2008, intimated that the land allotted to to the petitioner has not been utilized, and the company has not started commercial production even after 2 years from the date of taking over possession, with a further request to cancel the allotment of land and evict the company therefrom. WPC number so and so earlier filed by the petitioner to set aside the so-called notice dated 30/8/2006, which was just after the approval was given, the administrative approval was given for the additional land, was dismissed on 15/12/2008. The petitioner did not utilize the land for the purpose for which it was allotted and did not start civil construction within 6 months and did not start commercial production within 2 years from taking over possession. Subsequently, the OP IDCO rightly cancelled the allotment of acre 142 of the government land made in favor of the petitioner in its later numbers dated so and so 30/12/2008, with a further request to the petitioner to hand over the possession to Divisional Head IDCO Raurkela within 15 days from the date of issue of the letter. Subsequently, IDCO allotted the area of 142 acres to Messrs. Sham Steel Industries, which is OP number 3. Then, my lord, para 6. Deo Mines and Private Limited filed WPC number 19252 of 2010 against the state and another in the matter of setting aside the cancellation of allotment, with a further prayer to refrain the opposite parties for taking any steps or giving any effect pursuant to the impugned order dated so and so in respect of 142.12 acre of land in village so and so. The Honorable Court in their judgment in WPC number so and so, while setting aside the cancellation of the allotment, directed that it is open for the petitioner company to give positive undertaking to the corporation that the terms and conditions of the allotment of land and the lease deed will be meticulously implemented within a reasonable period of time that may be considered reasonably by the corporation to its satisfaction. If there is valid explanation by the petitioner seeking for extension of time, which shall be conveyed by way of representation to be filed within 2 weeks from the date of receipt of this order, the same shall be considered and appropriate order shall be passed. If time is not extended, as observed above, being not satisfied with the explanation for seeking extension of time for commencing the work, it would be open for the corporation to take necessary steps to cancel the allotment. Accordingly, the petitioner represented on 17/5/2012, stating that they have already taken steps for installation of the project, including project area fencing, land survey, water survey, soil investigation, etc., alienation of plant layout, etc. It also stated that they are taking steps for obtaining various statutory clearances, including terms of reference from MOEF for environmental clearance, permission for drawal of water from river Brahmani, permission for construction of power lines, etc. It is also stated that they have planned for completion of the project by June 2015 to December 2016, subject to obtaining the required statutory clearance in time. It is also stated that the project cost will be 405 crores, which was earlier it used to be 353, now it is 405 crores, and will generate employment for so and so people. They have also stated for earliest allotment of balance acre 117.88 of land to enable them to complete the project in time. The petitioner company has also furnished an undertaking as per the direction of the Honorable High Court in WPC number so and so. This proposal of the petitioner company is highly imaginary. Lord, they don't give any reason. They say exaggerated and without proof of records. Lord, I have given the undertaking, I have given the proposal, I have given what is required for it. My lord, I don't know what records, because the land records are theirs. What records they mean by that for setting up of a project are the clearances normally. That the company, it is not convincing that the company has planned to complete the project by 2015, June 2015 to December 2016, subject to obtaining the statutory clearance in time. It indicates that the petitioner company is not sure to obtain required statutory clearances in time. So this is a presumption which has been. If statutory clearance will be obtained in time, then the project will be completed by June 2015 to December 2016. Thus, it is conditional. And petitioner company is not sure about the completion of project as it will end in infinity. Even assuming such clearance in time, the project completion period is too long. They could have said, no, we don't want to give you this much of time. You reduce it, you complete it within this period. That also they have not stated. If even assuming such clearance, the project completion period is too long, which bears no meaning. It is evident from the past conduct of the company that they have consistently not shown any interest to implement the project. It is stated that the petitioner company is taking steps for various survey works, permission and clearances to start the construction work. Thus, the petitioner is only taking steps for such works and the work has not yet been done. It is also an undisputed fact that the purpose for which the land was allotted in favor of the petitioner company has not been put to use within the period stipulated both in the allotment letter and the lease deed executed in favor of the company. The fact remains that the allotment is of the year 2004 and the cancellation was made in 2008. The petitioner did not carry out any industrial activities for a long span of 4 years and retained the land idle till date for 8 years. Thus, the petitioner is not a serious player to implement the project. The deadline given by the petitioner to implement the project is far from truth and is not acceptable to the corporation. So the reasonings, whatever has been given, has been on conjectures and presumptions that I am not sure whether I'll get the clearances or not. The clearances are with the government agencies. Clearances I cannot dictate, my lord, as your lordship saw that the.
No, but if you cannot get, then that shows your incapacity.
But that stage has not come, my lords.
You cannot say that. See, what can I do?
No, my lord. I have to, unless I have to make the, my lord. Here the representation was to give a timeline for the purpose of making the necessary applications, because your lordship knows every industry before it sets up, even it starts commencement of the work, it has to get certain clearances. So I have to apply for them and get them. So they are presuming that I am not sure whether I'll get or not, because I said that if I get it on time, I never said that if I don't get it, I cannot do it. I said if it is within a reasonable time that I get, because there is no fixed, my lord, timeline when I will get the consents from different departments, because the government guidelines also don't provide for that. That within a single window facility, but it takes sometimes even 8 years.
Sometime ago,
My lord,
that's
single window. For 8 years, my lord, I can give instances which in other cases where 8 years it has taken even for the government's approval for the purpose of granting of the permission. So that is not in my hand. What is not in my hand. I cannot give a commitment that I'll get it within 15 days time. But if I get it within 15 days time, obviously my timeline will come down. So keeping a reasonable, my lord, timeline, I suggested that if I get all the clearances and get this additional land, I'll complete the project within this period. And I have not even, in spite of that particular land which I cannot use also, I have not sought for additional land. Yeah. I have said that within that land requirement itself, I'll complete the project. So the rejection, as my learned senior said, that this arises out of the earlier writ petition. The earlier writ petition, my lord, the issue was because I was not even noticed of the cancellation order. And apart from that, these issues were also there, which were taken care of by the, as I read out on the last occasion, then my learned senior said that we cannot get into that arena because that has been stayed by the Honorable Apex Court. But there it was only for the purpose of giving a representation, and if that is accepted or not accepted. And prior to the interim order that was passed by the Honorable Apex Court, the state government had already disposed of my application. This impugned order was passed even before the stay order was obtained from the Honorable Apex Court. So the issue is, my lord, here that when the earlier order was passed, they raised all these issues there. Also, the IDCO came up with that they have not built up anything. But this Honorable High Court said that no, the cancellation of the allotment is wrong for different reasons, and granted me an opportunity to make an application, detailed representation, where I will give a commitment that yes, I will do it within this time. And I have given that, and I have given the undertaking. It is not that I have not given the undertaking. If my undertaking by my investment, if I cannot do it, they can always take back. That is, I cannot claim even equity on that. But without even doing that, without granting me the opportunity even to start, they don't talk about the allotment of the rest of the area. They don't talk about that this, what has been given is not feasible for these reasons. Because I have detailed, my lord, if your lordships would see the representation. If your lordships look at the representation, I have given in detail what is the requirement. That is, my lord, page 33, annexure 5, my lords.
Yes.
So lordships should see in the very first page itself of the representation. Lord, the third paragraph starts with for installation. After the table, there are 2 lines, then below that, my lord, for installation.
Which paragraph?
My lord, in the page 33, annexure 5, the third for after there is a tabular, my lord, where the power plant and all this, that is my manufacturing facilities. After that, there are 2 lines.
Which annexure you said?
My lord, annexure 5 of the writ petition. Page 33, running page 33 of the brief.
Yes. Yes.
For installation, if you lordships. Lordships got.
Yes.
For installation of the project, total 260 acres land was recommended by EPCOL, out of which we have been allotted 142.12 acres of land by IDCO. As the allotted land was not sufficient for installation of all facilities mentioned above, we have also applied for additional land of.
We have seen.
My lords?
We have seen.
Yes. And the next paragraph also, where that which can be used, which cannot be because of the MOEF's objection or the conditions which has been imposed. Then, my lord, I have given the date line on the next page. Within what time I expect. And there's a specific date line I have given.
Yes.
Statutory clearances start May 12, end November 13. They could have said that these are, Lord, this particular may not take that much of time because these are the 1, 2, 3, 4, 5 clearances that is required. It may not take 15 months. It may take 9 months. Or, my lord, a year's time or maybe 6 months' time, whatever. Then, my lord, in each finalization of technical consultant, then basic engineering, detailed designing, everything I've given a timeline. Then, my lord, the last paragraph, we would also like to draw your kind attention to the observation of the Honorable High Court of Orissa in para 56 of the judgment, order dated so and so, wherein the Honorable High Court has observed, however, we make it clear that it is open for the OP number 2 to take such other action that may be warranted in the facts and circumstances of the case, unless the petitioner gives a positive undertaking to the corporation that within a specified period, the land which has been allotted in its
All right,
favor.
we'll take up tomorrow.
My one. Item 60 after
60.
Lordship, in fact,
At
item
the same time, 2 o'clock.
item 51, Lordship, in fact, the orders matter the condonation of delay, only 25 days delay, Lordship. But it has come up in admission list. Delay may be on Lordship, let it come in our orders, that matter can be taken up.
On your delay under the same heading. Let's see, the item 28
Lordship.
heading is
No, it was in orders, Lordship. Now it has come in after notice matter, Lordship. It is only for condonation of delay, item 51. So let it come on orders so that it can be this, Lordship, item 51. Yesterday it was in orders, Lordship.
Acha. When, then why it has been listed for admission?
Let's see, item 28, let's see. This is a matter pertaining to the Chilka, let's see. Some of my ponds has been demolished. When rainy season is coming, if I get a order from the honorable court, I cannot direct my pond. So let's see. That's the urgency.
All the matters will come tomorrow.
Let's see, tomorrow.
Item 60, day after 2.
The interim order is there. Subject
It
to
shall
also if
continue
no order is
tomorrow.
passed.
Tomorrow we are taking up the matter.